Hello, everybody.
Good morning.
Good morning.
Good morning, it is. Good morning, Board Member Smith,
Grand Rising, Chairman Blake.
Vice Chair Blake. Thank you very much.
So,
Let's see, 1, 2, 3. Well, I guess we're all here, actually. So I guess we should begin. Mr. Young, would you please start the video, the recording? Okay, good morning, ladies and gentlemen. The Board of Zoning Adjustments, March 5th, 2025, public hearing will please come to order. My name is Carl Blake, Vice Chair of the District of Columbia Board of Zoning Adjustment. Joining me today are board members Lorna John and Krishan Smith, and zoning commissioners Rob Miller and Anthony Hood. Today's meeting and hearing agendas are available on the Office of Zoning's website. Please be advised that the proceeding is being recorded by a court reporter and is also webcast live via WebEx and YouTube Live. The video for the webcast will be available on the Office of Zoning's website after today's hearing. Accordingly, everybody who is listening on WebEx or by telephone will be muted during the hearing. If you experience difficulty accessing WebEx or with your telephone call in, then please call our OZ hotline number at 202-727-5471 to receive WebEx login or call-in instructions. Today, we'll begin with our decision meeting session, followed by our hearing session. Please be advised that we do not take any public testimony in our meeting session. Public testimony will be taken during the hearing session. However, only parties are allowed to testify in appeals. In today's hearing session, everyone who is listening on WebEx or by telephone will be muted during the hearing, and only persons who have signed up to participate or testify will be unmuted at the appropriate time. Please state your name and home address before providing oral testimony or your presentation. Oral presentation should be limited to a summary of your most important points. When you're finished speaking, please mute your audio so that your microphone is no longer picking up sound or background noise. All persons planning to testify either in favor or in opposition should have signed up in advance. They'll be called by name to testify. Again, in the case of appeals, only parties are allowed to testify. By signing up to testify, all parties completed the oath of affirmation as required by Subtitle Y, Section 408.7. Requests to enter evidence at the time of an online hearing, virtual hearing, such as written testimony or additional supporting documents other than live video, which may not be presented as part of the testimony, may be allowed pursuant to Subtitle Y, Section 103.13. The order of procedure for special exceptions and variances is pursuant to Subtitle Y, Section 409. The order of procedure for appeal applications is pursuant to Subtitle Y, Section 507. Time constraints for hearing testimony shall be maintained pursuant to Subtitle Y, Sections 408.2 and 408.3. At the conclusion of each case, an individual who is unable to testify because of technical issues may file a request to leave the record open to file a written version of the planned testimony to the record within 24 hours following the conclusion of the hearing. If additional written testimony is accepted, then parties will be allowed a reasonable time to respond as determined by the board. The board will then make its decision at the next meeting session, but no later than 48 hours after the meeting. At the conclusion of the board's decision meeting session or hearing session, the Office of Zoning, in consultation with the chair, will determine whether a full or summary order may be issued. A full order is required when the decision it contains is adverse to a party, including an affected ANC. A full order may also be needed if the board's decision differs from the Office of Planning's recommendation. Although the board favors the use of summary orders whenever possible, an applicant may not request the board to issue such an order. Finally, the District of Columbia Procedure Act requires the public meetings on each case be held in the open before the public. However, pursuant to sections 405B and 406 of that act, the board may, consistent with its rules of procedure and the act, enter into a closed meeting on a case for purposes of seeking legal counsel on a case pursuant to DC Official Code Section 2-575B4 and or deliberating on a case pursuant to DC Official Code Section 2-575B13, but only after providing necessary public notice and, in the case of an emergency closed meeting, after taking a roll call vote. Madam Secretary, do we have any preliminary matters?
Late filings, the vice chair has reviewed.
Ms. Miller, I can't hear you.
Can you hear me okay? Yes.
We can now, yes.
Okay. In regards to late filings, the vice chair has reviewed and granted waivers to allow late filings into the applicable case record pursuant to Subtitle Y, Section 206.7 and Section 103.13. Any other late filings during the course of today's live hearing should be presented before the board by the applicant, parties, or witnesses after the case is called. Any other preliminary matters will be noted when that case is called.
Okay, Madam Secretary, if there's nothing else, we call our first meeting session days.
Yes, starting with the board's meeting session, the first case is application number 18878F of Alba 12th Street LLC. This is a request pursuant to Subtitle Y, Section 705.2 for a 2-year time extension of the validity of the order in application number 18878, which approved variances from the ZR 58 requirements for floor area ratio, rear yard, and parking. The project is for a new 9-story office building located in the D4R zone at 1017 12th Street Northwest, square 316, lot 36.
Thank you. This applicant is seeking a 2-year time extension for the validity of the order application number 818878. Now, the original order came effective in 2015, but was subsequently vacated and remanded to the board. The order on remand was effective date of February 18, 2021, and it's been extended 3 times. On a positive note, the applicant indicates that the owner is marketing the property for sale, with a potential buyer who is interested in purchasing the site and developing the project pursuant to the BZA order. And the requested extension would be needed to facilitate that sale and property development. The most recent time extension was granted in April 2023 and extended the validity of the order until February 21st, 2025. So if granted, this 2-year time extension would extend the validity of the order until February 21st, 2027. Pursuant to Subtitle Y, Section 705, the BZA can approve extensions for up to 2 years for good cause, with proper notification of all the parties and the determination that there's been no change in any of the material facts upon which the board based its original approval. In this case, the appropriate notifications have been made to the parties. I've reviewed the application, and I'll credit the Office of Planning's report in the determination that there have been no substantial changes in any of the material facts upon which the case was originally approved. The applicant has also demonstrated good cause in its ability to obtain sufficient financing due to economic and market conditions beyond the applicant's control. And that's consistent with the provisions of Subtitle Y, Section 705. So the Office of Planning recommends approval, and I believe the applicant has met the burden, and I'm prepared to support granting the 2-year extension. Mr. Smith, do you have anything you'd like to add?
I have nothing to add. I agree with your assessment of this case and will vote support as well.
Ms. John?
Thank you, Mr. Vice Chair. I have nothing to add. I'm in support of the application.
Chairman Hood?
Mr. Chairman, I ditto all comments. Thank you.
Okay, having deliberated, I will make a motion to grant a 2-year time extension with a new period of validity ending February 21st, 2027, and ask for a second, Ms. John.
Second.
The motion has been made and seconded. Madam Secretary, would you please conduct a roll call vote?
Please respond to the Vice Chair's motion to approve the time extension application. Vice Chair Blake?
Yes.
Ms. John?
Yes.
Mr. Smith?
Yes.
Chairman Hood?
Yes.
Staff would record the vote as 4-0 to 1 to approve application 18878F on the motion made by Vice Chair Blake and seconded by Ms. John.
Thank you, Ms. Miller. Would you call our next case, please?
The next in the board's meeting session is application number 20832A of 501 K Street Property Owner LLC. This is a request pursuant to Subtitle Y, Section 705.2, for a 2-year time extension of the validity of the order in application number 20832. This is for a new 14-story detached building with 550 residential units, 42,000 square feet of ground floor commercial space, below-grade parking, and penthouse. It's located in the D5R zone at 1001 6th Street Northwest, square 483, Lot 9.
Okay, thank you. The applicant is seeking a 2-year time extension of the validity of the order, application number 20832. The order became effective on December 28th, 2022. So if it's granted, this 2-year time extension would extend the validity of the order until December 28th, 2026. The applicant is requesting an extension in order to finalize the design and secure financing. And pursuant to Section Y 705, the board is authorized to approve the extensions for up to 2 years for good cause. Again, with proper notification up to all the parties and the determination that there has been no change in any material facts upon which the board based its original approval. Again, in this case, the notifications have been made to all parties. ANC 6C has filed a report in the record in support of the request with no reservation. There's also a report in the record from the adjacent ANC 2G in support of the project as well. And again, I will credit the Office of Planning's report and the determination there have been no substantial changes in any of the material facts upon which the board granted based its original approval. And the applicant, of course, has demonstrated its inability to obtain sufficient financing due to market conditions beyond the applicant's control, which is consistent with the provisions of Subtitle Y, Section 705. So I believe the applicant has met the burden. I plan to vote in support of the request. Mr. Smith, do you have anything to add?
Nothing to add. I'm in support.
Thank you, Ms. John.
I have nothing to add. I'm in support as well.
Okay, Chairman Hood.
Chairman, I'm in support as well. Thank you.
Okay. Having deliberated, I'll make a motion to grant a 2-year time extension with a new period of validity ending December 28th, 2026, and ask for a second, Ms. John.
Second.
The motion has been made and seconded. Madam Secretary, would you please take a roll call vote?
Please respond to the Vice Chair's motion to approve the time extension application. Vice Chair Blake?
Yes.
Ms. John?
Yes.
Mr. Smith?
Yes.
Chairman Hood?
Yes.
Staff would record the vote as 4-0 to 1 to approve application number 20832A on the motion made by Vice Chair Blake and seconded by Ms. John.
Great. Thank you, Madam Secretary. Would you please call in our first hearing session case?
Moving to the board's hearing session, next is appeal number 20944 of Advisory Neighborhood Commission 3D and Rohit Kumar. As amended, this is an appeal pursuant to Subtitle X, Section 1100, from decisions made by the Department of Buildings to issue building permits to allow a detached principal dwelling. It's located in the R1B zone at 5122 Cathedral Avenue Northwest, square 1439, lot 60. This hearing began on October 4th, 2023, and has been continued several times while awaiting the issuance of a revised building permit. Participating today are Vice Chair Blake, Ms. John, Mr. Smith, and Commissioner Miller. And as a preliminary matter, I believe the appellant has filed another motion to postpone.
Okay. Would the appellants please introduce themselves, whoever's here?
Chair Blake, Tracy Themack, representing ANC 3D, and Rohit Kumar, Commissioner Tricia Duncan, and Mr. Kumar are also in attendance with me.
Okay, do we have any representative from the Department of Buildings?
Morning, Chris Harrison, Assistant General Counsel on behalf of the buildings, I believe.
Mr. Harrison, I can't quite hear you, maybe a little bit muffled there.
Good morning, Chris Harrison, Assistant General Counsel, Department of Buildings. I believe Ms. Beaton, Zoning Administrator Beaton, is in the lobby as well.
Okay, is the ZA going to speak on this? Is she here? I don't see her. Okay, is there anyone else that will be speaking either from the appellate or the appellee? Okay, we received two submissions in the record, a status report from the Department of Buildings and a motion from the appellates to postpone. I want to start with the Department of Buildings. At first, Mr. Harrison, if you could just hear from you in terms of the status of the issuance of the new permit.
The new permit is still pending DOE approval, Department of the Environment, Energy and the Environment, for the stormwater management plan. The Department of Buildings has not been notified of an approval. I believe it is still pending with them, but at this time the permit will not issue until the DOE approval is transmitted. I would note that this is not a zoning issue.
Okay, but that is actually good news. Do you have a sense of how long it might be before the pending permit might be issued, or we might get something from the DOE?
If the DOE has comments and has requested additional information, that would depend on the applicant. Again, we were here basically in the same posture in December. DOB's completed its reviews of its disciplines, including zoning, and we're awaiting the stormwater management review.
Okay, well, I actually think we're a little bit further along than we were in December in that the applicant has submitted the materials. I believe is that confirmed, Ms. Themack? Ms. Themack?
I feel at this point there's some concern, especially because Mr. Kumar, one of the appellants, is the rear neighbor. I think the stormwater management issue is a huge one. So the fact that that's still in play is still a concern, and I'll let both Mr. Kumar and the commissioner speak to that. I do think we're making progress. I think more time will allow for that, but with the sloping grade and the potential impacts, especially to Mr. Kumar's property, I think we want to know that the issued permit solves all the problems. And one of the major ones we need to know is that DOE signs off as this is an appropriate stormwater management plan. I defer to Commissioner Duncan and Mr. Kumar to see if there's anything else they would like to add.
All right, Commissioner Duncan.
Thank you. We actually are in the exact same position as we were in December. DOB had signed off on their part of the plans, and we were waiting for DOE then too. So from our standpoint, nothing has changed since December. And we respectfully ask the board to once again rule that we can keep this on the docket until a building permit is issued. Thank you.
Okay, Mr. Kumar, do you have any comments you wanted to make?
No, I just second that. I am the downhill property owner, so the stormwater management issue is directly relevant to me. And as Commissioner Duncan has said, and Ms. Themack has said, we're just in the same place we were. I'm really hopeful, and I know we've said this now like 4 or 5 times, but I'm really hopeful that we get another, kick the can down the road for another 2-3 months, whatever it is, that between now and then we will reach resolution on the issues and we will be in a position to jointly request a dismissal. We're not there yet, but we are, Vice Chair Blake, as you know, we are further along than it feels like we were a couple months ago, but we're just not all the way there. But I really feel like we can see the finish line.
Okay, that's great. So Ms. Themack, let's go back to your request. The motion on the floor is for a 30 to 60 day postponement. What realistically, based on what we've heard just now, we're gonna have to have enough time for that, the DOE to come back, if there's some comments from there, and for the uh, Department of Buildings to actually issue a permit, and for the review, for the review. What is a realistic time frame? That is 30 days? It sounds like 60 days is probably much more reasonable.
I would
Um,
agree.
you think so? Okay, how do you think about
I
that,
would
Mr.
agree. I would rather not put you through another meeting to just do this and have everybody attend. And I think given that the last one gave us roughly 3 months and we didn't get it in that time frame, 60 days is even still optimistic, but I'd like to give it a chance and see if we can urge DOEE to get us this final piece so that we can get an issued permit and get ANC and Mr. Kumar's review of it. So I would lean towards 60 days.
Okay, Mr. Harrison, what's your thought on that? Is 60 days enough, or do you think that's unrealistic?
And Chair, but thank you very much. It's impossible to tell, again, we were here last time in December with the stormwater management plan required. It was not filed until the middle of last month. So it's entirely dependent on the applicant. Again, the department, though we are not going to affirmatively object to a continuance, I do want to point out again, we do have a pending motion to dismiss, and the zoning issues have been addressed in this permit review process. If there are zoning issues that the appellants wish to raise with the proposed plan, I would like to hear them. Requested that from Ms. Thiemek on a couple of occasions. This is not the Board of Stormwater Management Adjustment.
Okay, I understand.
respectfully,
I understand what you're saying, Mr. Harrison. I do. But the question was, do you think that the 60 days is enough time? And you're saying maybe.
It would not hazard a guess. We would have to ask the applicant.
Okay, Ms. Duncan, I think you had a comment about the timing for the ANC.
60 days, I would like to hear from the applicant because he may have some ideas on along
I'm
the
going to put that. Thank you, Mr. Agarwal. I will turn it over to you. Please give me your thoughts on that.
Good morning, board. Well, the update is, I just want to correct the record here. We had submitted our first round of stormwater management plans back in early December. So it's incorrect to say that we only submitted last month. We submitted our second round last month, and we had gotten some comments from stormwater management. We then resubmitted our second round. We got back some comments last week. We are on, I think, just 2 or 3 remaining comments right now. Our engineering firm is in the process of responding to those 2 or 3 comments, which are relatively minor, and the rest of them have been accepted. So the comments now are, just administrative corrections to the soil type and things like that. So I assume we're going to be making a resubmission Friday end of day for then DOEE to review sometime next week. DOEE's pretty much been turning around their reviews between 5 to 7 business days from the time we've been submitting it. At least that's what's happened in the last two instances. So I would like to assume that maybe 2 to 3 weeks from now, DOEE will probably transmit the approval to DOB. At least that is the update that I would like to share based on previous instances. However, if I may also add, to second Mr. Hairsign, this is, the BZA case was to deal with specific zoning issues that have been dealt with. I've been here penalized for 2 years now, and my property is sitting blighted. I'm not able to get back to work. I'm running up, huge costs. I have a $75,000 property tax bill on the property, and I need to get back to work there. And so, I understand the appellants want to obviously get this permit in their hands and see it. But the point is that everyone has seen the new plans, the proposed plans. DOB and zoning have confirmed that they have approved the plans that everyone has seen. In the last couple of months, I haven't heard a single zoning objection from anyone. So if we are no longer here for the purpose of zoning, then I believe we should no longer have to come back to this board because the zoning issues have been
Okay,
resolved.
Mr. Perkins, I understand. Thank you very much for the update. Ms. Thiemek, Mr. Agarwal indicated that he shared with you the plans as they currently exist. Has that taken place?
We have the most recent set of plans. That is correct. We are waiting to see I don't believe, and Commissioner and Mr. Kumar, you can correct me if I'm wrong. We haven't seen the stormwater management changes. We need to see those. And I guess I would reiterate, we're waiting for final issued approved building permit plans to know that all of the zoning matters have been addressed. We really can't go on preliminary plans. We need to know what is authorized and what is planned to be built. So
Okay.
the issue of
It,
zoning still remains.
it sounds like the appellants are at the ready, and as soon as that information becomes available, will be positioned to act. Given that, I'm going to turn to my board now. We've heard a great deal of commentary, and board members, if you'd like, I'd love to get your sense on that. Obviously, the issue is 30 or 60 days. I think 60 days is the direction that seems to make the most sense. It'll take time for them to get through this. I'd love to get your sense on this, Mr. Smith.
I agree of the two. I think 60 days makes the most sense. It does take time for this to get through DOEE, get a final permit through DOB. So I think even 60 days is aggressive. I would have said 90, to be completely honest. That would be my preference, would be we come back to this in 90 days before we go on our recess. So I would put out 90, not even 30. I would say 90.
Okay, Ms. John.
So, I'm in two minds. Part of me wants to think that the zoning issues are resolved. So, you know, we can probably dismiss the case, but on the other hand, since we're at this point, we've granted a few continuances, and I don't think an additional continuance of, I would say, 90 days should be too prejudicial to the property owner. So for that reason, I would support 90 days, and I hope that's the last continuance.
Miss Vice Chair Miller.
Thank you, Mr. Chairman, and I agree with all the comments. I'm sure I'm getting an echo here, but are you hearing an echo?
No.
Yes.
Okay.
Well, you're breaking up. You're breaking up slightly. It's not an echo.
Okay. I agree with my fellow board members, and I support the continuance of the hearing. I mean, we've delayed we've continued it several times because there isn't a final approved building permit, and we wanted to keep this case alive so that hopefully the issues will be resolved and the appellant can just withdraw the appeal. That's what they wanted all along. So hopefully this will get resolved, but there isn't a final issued building permit for us to for us to dismiss it would be counterproductive to what we've been trying to accomplish throughout this process. We have not penalized the building permit applicant. The building permit applicant has not received a final approved building permit, and we want to consider that. The appellant wants to look at that, and so I support the continuance, and hopefully this case will go away within the time period we're talking about.
Vice Chair Miller, what was the time frame that you felt most comfortable with?
I support whatever my fellow board members support, 60 days, 90 days. If it sounds like it may be able to be accomplished within the 60 days, I'll defer to you, Mr. Chairman.
Okay. Then I think we have a consensus that we will postpone. And it sounds like we're leaning towards 90 days, in which case this will hopefully resolve itself. So, Madam Secretary, I'd ask that you please look at the board's calendar and give us a date, 90 days hence.
So I would put put you sometime in June. I would recommend either right before or right after the July 4th recess. So July 2nd or July 16th.
Okay, thank you. Would you say July what? 16th?
July 2nd or July 16th.
Okay, let's put it on for July 2nd.
Okay.
Okay. Okay, thank you. So the motion to postpone is granted by consensus, and the appeal is scheduled for June 2nd,
July.
July 2nd. Thank you.
Thank you.
Thank you. Thank you, everybody. We will see you, hopefully not at that time. Vice Chair Miller, thank you very much for joining us. Have a great day.
Thank you all.
You have a great day too. Thank you.
Okay, okay, let's see. First of all, does anyone want to take a quick coffee break, or are we good to go? The answer is good to go. Okay, so we'll move to our next case in the hearing session. Ms. Miller, thank you.
Next is application number 21211 of 28th Street Holdings LLC. As amended, this is a self-certified application pursuant to Subtitle X, Section 901.2 for special exception under Subtitle U, Section 421 to allow a new residential development. This project is a new 3rd-story and 3-story side and rear additions to an existing 2-story detached building for use as a 19-unit apartment house. It's located in the RA1 zone at 2826 28th Street Southeast, square 5729W, Lot 5. This was postponed from the January 22nd hearing at the applicant's request, and I'll also note there is a revised self-certification form in the record in Exhibit 32A.
Okay, if the applicants are here, would you please introduce yourself, Mr. Williams? I see you there.
Good morning. My name is Zach Williams. I'm a land use attorney with Venable. I'm representing the applicant in this case. The applicant is here as well, Mr. Matt Medvine, and the architect Ryan Petiak is also online.
Okay, Mr. Petiak and where's the architect? Mr. Medvine, would you please introduce yourselves the rest for the record?
Good morning. Yes, my name is Matt Medvine. I am the applicant.
My name is Ryan Petchak. I'm the architect.
Okay, Mr. Williams, we're going to proceed with your statements. And if there's any, is there anyone from the, is anyone from the ANC here? I don't think so. Okay, we have Ms. Myers. Okay. We're going to hear from the applicant, then we're going to hear from the Office of Planning. I see Ms. Myers is here, and then we'll take any public testimony, which I don't think there is any. So the members of the board should feel free to ask questions at any time throughout, and the applicant will have an opportunity to ask questions of the ANC after they commit their final their remarks. So, Mr. Williams, if you would please go and tell us about your product and how your client's meeting criteria for approval. I'll put 15 minutes on the clock, and you can begin whenever you'd like.
Great, thank you. We do have a brief presentation if Mr. Young could pull that up. Great, thank you. This is an application for an expansion of an apartment house at 2826 28th Street Southeast. As I mentioned, I'm representing the applicant. I'm a land use attorney with Venable LLP. Next slide, please. This is the zoning map for this case. As you can see here, this is a large corner lot. The existing structure is a fully detached existing apartment house with 5 units. This is an application to add 14 units to the structure for a total of 19 units in the RA1 zone. Next slide, please. Here you can see the existing survey, again showing the existing structure, a fully detached 5-unit apartment house. It's a 2-story structure currently on the property. Again, this is a large corner lot, as you can see here at the corner of Gainesville Street and 28th Street Southeast. Next slide, please. Here's some photographs of the current conditions of the house. On the left, you're seeing the front of the house, of the apartment house, I should say. And you can see the rear of the apartment house on the right-hand side of the screen. Next slide, please. And each of these respective photographs are the side yards and side of the existing structure of the apartment houses that exist today. Next slide. So the proposed project is to expand the footprint and to add a third level to increase the existing 5-unit apartment house to a total of 19 units. So we'll be adding 14 units, including 2 inclusionary zoning units, which are shown on the plans. This is because this is an existing apartment house in the RA1 zone. Any addition of units requires special exception relief. Next slide, please. So the relief we're requesting is simply to add the 14 units to the existing apartment house. All of the work is by right and permitted in this zone without any further zoning relief necessary. Under subtitle U, section 421, any addition of units to an existing apartment house in the RA1 zone requires special exception relief, as I mentioned. Next slide, please. I'm going to walk through the general special exception standards here and how this project is meeting those requirements. First, as we know, the project must be in harmony with the general purpose and intent of the zoning regulations. Here, the RA1 zone allows for low to moderate density development, including detached dwellings, row houses, and low-rise apartments. This apartment house is existing. This block, in fact, contains almost all apartment houses, so it's very typical in the neighborhood and in the zone to see a project such as this. As I mentioned, the project will meet all of the development standards in the RA1 zone. We're not seeking any additional relief for this project. We'll also be adding solar panels on the roof of the new addition, and those will be used to fully power the project once completed. Next slide, please. The next standard for special exceptions is that the project should not adversely affect neighboring property. And in instances such as this, we typically think of light, air, privacy, noise, things like that that could impact neighbors. Here, the project will not impact those properties because for a number of reasons. First, it will remain a fully detached structure as it is today. It will meet all of the yard requirements that are required in the RA1 zone because it's a corner lot. We have 2 of the side property lines are along roads rather than neighboring properties. As I mentioned, the neighboring uses are also apartment and multifamily residential buildings. And at the request of the community, we did add another parking space. There was some concern about parking here. We're required to have 3 spaces. We initially had 4. We now have 5. So that was a change that we did make because there was some concern about that from neighbors. Next slide, please. Here are some shadow studies. Again, to show that there's very limited impact of this project. We are adding a 3rd story. Initially, we had a 4th story, but we took that off to try to keep the massing in harmony with the neighborhood. As you can see here, really by virtue of the fact that this is a corner lot and a detached structure, the new shadows that will be cast have almost no impact on any neighboring properties. Again, satisfying that second major standard for a special exception. Next slide, please. In terms of our ANC and community outreach, we started outreach right away with neighbors. We went around and knocked on doors of all of the neighboring properties on the block. We also met with the ANC 8B twice. We presented in December and then again in February. We're very happy to receive the support from the ANC at its February meeting. That took several months of working with the ANC and addressing concerns, making sure that folks were comfortable. We also had a turnover of commissioners, so we had to work through that and make sure that the community felt good about this project, and we got to the point where we had unanimous support. So we're very proud of that, and that letter should be in the record. Next slide. I think that might be my last one. Yeah, I think it is. I'll also mention that, as you'll hear, Office of Planning is in support and DDOT does not object to the application. We're here for any questions. Thank you.
Thank you, Mr. Williams. Do we have any questions from the board for the applicant? Okay, then having none, we'll turn over to the Office of Planning. Ms. Myers, please introduce yourself for the record.
For the record, Crystal Myers with the Office of Planning. The Office of Planning is in support of this case, and we can stand on the record the staff report, but first here for questions. Thank you.
Okay, thank you, Ms. Myers. Does anyone from the board have any questions for Ms. Myers or the applicant at this point? Okay, hearing no questions. Do we have any last final remarks from you, Mr. Williams? Oh, I'm sorry. Wait, is there anybody from the public that wishes to speak?
No, we do not.
Okay, I just wanted to confirm that. So now, having heard that,
Mr. Vice Chair?
yes, sir. Yes,
I
ma'am.
have a quick question for Mr. Williams to clarify the owner of the property. Is it 28th Street Holdings or 28th Street SE LLC?
Yes, it's 28th Street Holdings LLC. There was a purchase during the course of this application, and so that's the current new owner, 28th
Okay.
Street Holdings LLC.
All right, thank you.
Okay, Ms. John, thank you very much for bringing that clarification. Okay, Mr. Williams, do you have any other comments for closing?
I do not. We appreciate Office of Planning support. Thank you.
Okay, thank you very much. So I'll dismiss the witnesses at this point, and I guess we can go into our deliberation session. I'll kick it off from this perspective. The applicant is seeking a special exception for the subtitle use section 421. There's no other relief requested. The building itself conforms with the developmental standards of the zone, of the RA1 zone. Therefore, it's presumed that it should not adversely affect the use of neighboring properties with regard to light, air, or privacy. The use is also permitted in the zone by special exception, and its design is in line with the apartments, buildings in the vicinity, and it is compatible with the neighborhood. So I would credit the analysis provided by the applicant is very thorough, and also credit the Office of Planning analysis of how the applicant has complied with the criteria, and give great weight to its recommendation for approval. I'd also want to commend the applicant for working collaboratively with the community and the ANC and the Office of Planning to create a project that aligns with the zoning regulations and addresses the community concerns, for example, the parking. I'd also like to thank the ANC for working with the applicant and community to reach an amicable resolution. And I'll give great weight to the ANC's written report, which is in support of the application and states no issues or concerns. I'll also note that DDOT is in support of the application, but proposes a condition that I'd not be inclined to include in that provision in the board's order. As the application meets the needs of the zoning requires with regard to bicycle and actually exceeds it modestly with regard to vehicle parking. And there's really no issues or concerns identified by the DDOT that needs to be mitigated. So that said, I'll be voting in support of the application and ask Mr. Smith to, if he has any additional questions or comments.
Chairman Blake, I think you have thoroughly summarized the metrics of this case and the reasons why we should grant approval for this. I agree with everything that you've stated and everything that was in OP staff report that would support us approving this particular special exception. And I will vote in support as well.
Thank you, Ms. John.
Mr. Vice Chair, I'm also in support of the application.
Thank you, Chairman Hood.
Thank you, Mr. Chairman. I would agree with your compliance with subtitle U. I think it warrants our approval, as well as I want to commend this applicant for the double in community engagement. I think that's probably where we are with this case at this point. Thank you, Mr. Chairman.
Okay, thank you. Having deliberated, I'll make a motion to approve the application as read and captured by the secretary and ask for a second, Ms. John.
Second?
Okay, the motion has been made and seconded. Madam Secretary, would you please take a roll call vote?
Please respond to the Vice Chair's motion to approve the application. Vice Chair Blake,
Yes.
Ms. John,
Yes.
Mr. Smith,
Yes.
and Chairman Hood.
Yes.
Staff will record the vote as 4-0 to 1 to approve application 21211 on the motion made by Vice Chair Blake and seconded by Ms. John.
All right, thank you. All right, let's do this. I know we seem to be going at a pretty good pace here, which I like. The next case may take a minute though. So for that reason, I'd like to take a 10-minute break, 15-minute break. And then we'll get back here at 10:30, okay, 10:35, let's say, and we'll dig in, okay? Thank you. Okay, Ms. Mallard, are you there? Madam Secretary, there?
Yes, I'm here.
Okay, Ms. John will be joining us shortly. I think she's listening, but don't think she can put her screen on. So why don't we go ahead and call our next case?
Sure, the board is back from its quick break and is returning to its hearing session. The next case is application number 18431A of the Field School. This is a self-certified request pursuant to Subtitle Y, Section 704 for a modification with hearing to modify the order in application number 18431 with modifications and conditions and approval of special exceptions under Subtitle U, Section 203.1M to allow addition to a building in an existing private school. Subtitle X, Section 104 to allow modification of a private school plan, and an application pursuant to Subtitle X, Section 901.2 for a special exception under Subtitle C, Section 1402.1 from the maximum height requirements for retaining walls of Subtitle C, Section 1401.2. This project involves changes to an existing private school use, including modifications of conditions of approval to allow increased enrollment from 400 students to 425, an increase in full-time equivalent faculty staff from 110 to 120. Also, the modification of a private school plan to allow a two-story addition, the reconfiguration of existing parking areas to create a new practice field, the reconfiguration of an existing surface parking lot and bus parking zone. And lastly, there would be 3 new retaining walls. This is located in the R1A and R1A/WH zone at 2301 Foxhall Road Northwest, Square 1341, lots 856, 861, 878, and 879.
Okay, could we have everyone introduce themselves? We'll start with the applicant's agent and the applicant.
Yes, good morning, Vice Chair Blake and members of the board. My name is Christine Scheiker. I'm with the law firm of Holland and Knight, representing the applicant. We have a variety of people on the call, but I think we're going to just start with introductions of a few of them, and then we'll bring others up as needed if there are questions. Lori, if you'd like to introduce yourself.
Good morning, everyone. My name is Lori Strauss, and I am the head of school at Field.
Nancy.
Good morning. I am Nancy Grebelock, and I am the architect with Perkins & Well, designing the school for the Field School.
And Jamie.
Good morning. I'm Jamie Milanovich with Wells & Associates, the transportation consultant for the project.
Okay, I see you have several other people on that, so I'll assume that they will be joining us as need be to answer questions. So at that time, we'll have them introduce themselves, etc. Okay? All right. I want to just, Madam Secretary, are there any preliminary matters?
No preliminary matters.
Okay, then we will proceed. What I'd like to do here is just talk a little bit about the format. Really, this is for the benefit of the public. I know we all, the professionals here would probably be very comfortable with it. I want to talk a little bit about the format of the hearing and the burden of proof. The hearing is going to be conducted consistent with the hearing session in WILD 409, Section 409, for special exception requests. This is a unique hearing in that it contains a number of special exceptions that result in modifications to the conditions, and then there's some conditions that are going to be modified that fall outside of that, and there's some special exceptions that don't require it all. So it's a little bit of a differentiation. It's going to kind of blur together, but we will be conducting the special exception proceeding normally. But because of the modification, the existing order, which is pursuant to the scope of the hearing, will be limited to the requested modifications on the subject of the original application. The hearing will focus on the relevant evidentiary issues requested for the modifications and any condition impacted by the modification. That's per subtitle Y, Section 704. So regardless of today's outcome, since the special exceptions for the existing private school use and the private school use are already vested, if the modifications are granted, the existing provisions of the existing order will still apply. So in other words, If the applicant gets a modification, it's modified. If they don't, it maintains and the way it is, status quo. The school doesn't stop. We can't revisit the act. So I want to speak to Ms. Shiker about this. I've looked over your presentation, your prepared slides, and reviewed the proposed modifications. I think they're presented in Exhibit 26B.
The conditions are in Exhibit 26B, and our presentation is, I don't have the exhibit. 34 is where our presentation is, to go through all of the different modifications and the newly requested special exception relief for the retaining walls.
So as I can see, there are 38 conditions in the current order, and you're looking to modify or eliminate 22 or 23 of those conditions. That's a lot. So as you know, the board's conditions are in the orders are designed to mitigate potentially adverse impacts. So it'd be helpful for me if you could provide some additional detail on the rationale for the proposed changes, as the board needs to really base its decision to remove or modify any conditions based on substantial evidence in the record. So, some things are definitely tied to the special exceptions. Some things are arcane. Some things are just out there. So I want to make sure that we have a substantial evidence and record to address that. Now, so you can do that as depending on how things go, we're going to go through all of those provisions individually to fix to amend the order. So what we'll need to do, it'd be very helpful if you could help us connect the dots over the course of your presentation, or at the end, actually going through the individual ones and kind of making sure we've got the rationale for the mitigations or not mitigations. Do the issue still exist, et cetera, so we can work through that. In other words, just help us connect the dots. Okay.
Absolutely.
That's it. Would you please proceed?
Yes, before we proceed, we did request, or just wanted to note that both the architect and the transportation consultant are qualified experts in the book. We have provided them as expert witnesses for this testimony. And if I could have Mr. Young pull up our PowerPoint presentation, please. Thank you. Thank you very much. And again, Christine Shiker with the law firm of Holland and Knight representing the applicant. Next slide, please. So the field school is located at 2301 Foxhall Road. That's between Foxhall Road and 44th Street, which is on the west side of the Glover Archibald Park. The property is comprised of 4 lots, the significant majority of which are zoned R1A. And the site around the school is generally residential, but it also has institutional uses. Next slide, please. The field school was established on this site in 2000 by virtue of BZA order number 16559. There were some temporary amendments to that order, but most recently in 2012, BZA order 18431 allowed for an expansion of the campus. And it is in this order that the current conditions were established, including the number of students as well as the faculty and staff. And as was requested, we will go through those conditions and how they change with this proposed application. Next slide, please. So the application requests approval of a modification to the private school plan. These modifications include the construction of the Innovation Center, which is going to be in addition to the campus building. It incorporates minor upgrades to the existing athletic fields, including the addition of field lighting that we're going to talk about during this presentation, and the relocation and replacement of the scoreboard. It also includes a reconfiguration of the existing basketball court and northern parking area to allow for a new practice field. It reconfigures the existing surface parking lot and provides parking in excess of what is required by the zoning regulations. And it results in modest increases to the student enrollment cap from 400 to 425, and from the faculty and staff cap from 110 to 120. Both of those increases are anticipated to happen gradually over the course of several years. In addition, the application requests new relief, which is a special exception to construct 3 overheight retaining walls. As you have seen in the pre-hearing submission, the application was modified since originally submitted due to changes in the athletic field. So originally we had significant revisions to the athletic field that resulted in retaining walls that were closer to adjacent neighbors. Following work with the neighborhood and with the ANC, we revised the changes to the athletic field to eliminate the retaining walls that were causing concern. So therefore, the only retaining walls that remain are the 3 more modest retaining walls in the center of the campus, and the architect will walk through those during her testimony. Next slide, please. Again, the conditions are a very important part of any private school plan, and the applicant does propose to revise those conditions. At the end of our presentation, we will pull up this comparative chart, walk through each of the revisions and how we have presented the testimony as requested. Most of the changes are based on the field school's work with the community, and many of these relate to the expanded use of the athletic facilities and proposed field lighting. These conditions have been worked closely with the community, and I think you'll see how those are connected when we walk through them. We also included an updated construction management plan to reflect construction of this addition versus a previous edition. And in the work with DDOT, we have substituted the entire transportation demand management plan for a new updated plan that reflects current standards. Next slide, please. We are very pleased to have extensive support for this application. OP has supported the application and has no issues with the conditions. DDOT has no objection, subject to the condition for the TDM plan. Please note there was a bit of a clarification on which TDM plan, and there's a submission in the record that clarifies that, and Ms. Milanovic will also speak about that in her testimony. We're very pleased to have unanimous support from the ANC on this application, and this support follows significant work with the community that began well before we filed this application. The ANC report does reference 6 commitments that the applicant made. Each of those commitments is in those conditions that we'll talk about at the end of the presentation. There is other support from the Palisades Community Association and a nearby neighbor, and there is no identified opposition to this application. And that's always a great feat for a private school plan in an R1A zone to come in with. So what I'm going to do is I'm going to ask Ms. Strauss to talk a little bit about the field school and the community work. The architect will then walk through the proposed improvements. Ms. Milanovic will talk about the transportation, and then I'll walk through the compliance with the legal standard and the conditions. So Ms. Strauss, and next slide, please.
Thank you, and good morning again. As you just heard, Field moved to this campus in 2000, and we opened our doors on Foxhall Road in 2002. Since that time, our 6 through 12 program has really embraced inquiry-driven and student-centered education. I like to say that we are not only raising strong academics, but also students who will be engaged neighbors, informed citizens, and interesting dinner guests. And when you are raising students to be all 3 of those things, it's really important that you have adults and an institution that models those back to them. And so a key part of where we are here in DC, as you just heard, is that we are largely in a residential area with some other institutions surrounding us. And so a priority of being here in this area is being a good neighbor. And that is not just words, it's an actual ethos of the school. Part of this is our size. We have fewer than 400 students on our 10-acre campus, and we have the space and natural buffers that allows us to make use of our indoor and outdoor campus facilities in a manner that doesn't disrupt the quality of life of our neighbors. But a part of this really is our school culture. So neighbors are encouraged to share the use of our field and outdoor facilities, which they readily do whenever we are not using it. And we have a neighborhood gate from which they can access those outdoor facilities outside of school hours. If there is a rare event when an issue arises with a neighbor, we address it swiftly and directly, and we take steps to really ensure that it doesn't occur again. As a result, what you'll hear and you have heard is that our relationship with the community is built on a foundation of trust, and we are consistently working to maintain and foster those relationships. And it's why we come with such unanimous support. In 2022, it was the 50th anniversary of our founding, and we engaged in a large-scale master planning process. It was a really thoughtful process to revitalize our facilities. Since then, we have redone all of our science classrooms. We have actually also redone indoor spaces on a building to better ensure that all of our students can fit into our classrooms. And as you just heard, the next stage is proposing a construction of a new innovation center, which will be critical to enhancing and advancing the educational experience of our students. It provides additional classrooms and community areas, as well as studio and art gallery space. And in addition to that innovation center is the repurposing of an asphalt area as a practice field, as well as enhancement of our current competition athletic field and adding lights to it. This was actually done at the encouragement and support of the ANC. There is a very high demand for high quality recreational space for youth sports and other schools in our area. And so we would really like to be a better neighbor, and having those nights will allow us to actually have a process by which schools in the area and youth sports can utilize those outdoor athletic spaces. These projects are really transformational for our school, but they're also pretty low key, not disrupting the current aesthetic or really changing what anyone sees from here on campus or in the neighborhood. Our current student population is slightly below that cap of 400. And as part of this application, we're asking for that modest increase to 425, as well as that modest increase in faculty and staff from 110 to 120. If you could go to the next slide. As I was talking about at the beginning, a very significant part of the last few months has been our conversation with the community, with individual neighbors at their homes, with two large-scale meetings, one virtual and one in person at the school, as well as continuous conversation with all of the stakeholders to make sure that all the questions were answered and issues were successfully resolved. They all have been. And this is a summary of those commitments that we have made to our neighbors. It is as a result of this really collaborative effort with our neighbors and the ANC that they did vote unanimously to support our application. It's an incredibly exciting time here. I'm really happy to be head of school at this time and to be here before you with such support for our next step in our evolution, and to really be the good neighbor and be the role models that we hope to be for all of our students. So Nancy, I think you're gonna take it from here.
That's good. Thank you all. Next slide, please. So I want to share with you the graphics that support what Christy and Lori were describing. What we have here is an existing site plan. I want to go through a quick overview of the existing conditions of the school site. Right now, the school has 6 interconnected buildings that you see numbered on the screen, 2 areas for bus parking in the north and the south side of the campus, a small basketball court on the north side. We have also a steep slope that falls down towards the soccer field from the existing building, and this is controlled by a couple of retaining walls right now. The school also has an athletic field, a soccer field, and as you see in the screen here, there is an existing scoreboard to the north of the field. Next slide, please. So here we want to share with you the proposed design and the site plan. The proposed design will mainly focus on the expansion that we talked about, is labeled 7 in this plan. And this expansion will be designed to meet all the school programmatic requirements. In terms of the site improvements that we're including are the reconfiguration of the parking lot in the south side to consolidate the bus parking that is now partially in the north and the south, so we want to consolidate that area. We are also proposing only resurfacing the soccer field in its current location. We have relocated the scoreboard from the north side of the field to the east side, so it faces the school and not the neighbors. We have added 4 light poles for the field. We are upgrading the stormwater management plan, and all the hardscape and landscape design that we're proposing will be developed mostly around the existing buildings and the new expansion, creating social zones, bioretention areas, and planting areas. Next, please. So this rendering here that you see of the proposed expansion is, you can see here that the addition is placed within the existing building, and it tries to blend with the rest of the campus. The intent for the design of this expansion has been to strategically locate it where it can connect to the adjacent buildings, and at the same time to allow for a terraced accessible route to the field through ramps and social seating areas for the students. Next, please. Here we quickly want to show that the area in the blue is showing the expansion beyond the front elevation of the building. You can see here how we're trying to connect to the lower levels of the campus. Next, please. So Lori and Christy talked a little bit about the lighting that we are adding to the field. Right now it's a dark field. So the school is proposing to install 4 new lights around the perimeter of the existing field. The whole team, the school and as the architects, have been working closely with the neighbors to find the appropriate levels of lighting to satisfy both the school uses and the community. So basically the position of the poles, the height of those poles, the illumination levels, they were all carefully designed to control the light spill into the neighbors. Next, please. The school has reduced the proposed field lighting levels to an average of 30-foot candles to make sure that it's low enough to satisfy the uses, as I said before, but control the spill. Next, please. And in addition, the new lighting will be directed downwards and result in minimal impact to the abutting neighbors. To further limit the impact of these lights, the school is proposing a condition to limit the use of the lights to 9 p.m. Next, please. So, as I mentioned before, the expansion is located strategically to moderate the slope while providing an accessible route to the field. The accessible route is shown here in a dashed line. You see how the students can come down to the field. We are accomplishing this through ramps and nicely landscaped seating areas. So as you can see, in order to do this, we had to relocate the existing retaining walls. We have 3 different conditions here shown in 3 different colors. If you move to the next slide. Thank you. The first condition here, in this shown in blue, you see the existing retaining wall, and the proposed retaining wall here is at the edge of the athletic field. It slopes with a ramp, and it varies from 0 feet to 11'6". The second relocated wall, in the next slide, please. Thank you so much. It's shown here in orange, and is integrated within the landscape and follows the accessible ramp. Lastly, on the next slide, we have the third condition, which is a wall that is needed to support the new turf practice field. And you see the before and after. And that kind of summarizes the retaining walls for the project. These are far away from the neighbors. They're within the campus. So it doesn't make a big difference from what you can see before. Next slide. I think we have the traffic report. Jamie?
Yeah, thanks,
Before you go on
Nancy.
there, before you go there, could you talk a little bit about the alternatives that you looked at? I think there were some other terrace structures or something that you considered. Could you just talk a little bit about that and why that does or does not work?
Yeah, so the alternative options we looked at were related to the retaining wall when we were doing a new field. And Christy talked a little bit about that, how we had a big tall wall next to the neighbors. So we were trying to study different solutions in order to mitigate the height of that wall. After working with the neighbors, we abandoned that altogether, and we just focused on being away from the school. In terms of the ramps that you see here that we're asking for relief, the studies had to do with how we come down from the building to the field in a gracious manner that is incorporated into the design and the landscape. So we landed in a way with this configuration that, as you can see, blends in within the context of the campus.
Had you looked at one other alternative that would have had an impact on the field size or something?
Yes, we looked at different locations for the field to see if we can rotate it or move it straight, but that was all in relation to that retaining wall that we were trying to do. Since we abandoned that project as a whole, we're now keeping with the existing field as is. We're just changing the surface, so no modifications there.
Okay, thank you.
We did also provide in our plans, which are in Exhibit 26A, some projections if we had terraced these 3 retaining walls as well. They're on 53 and pages 48 through 53, which also shows the practical difficulties that we would encounter if we tried to terrace those. So we had significant studies on the original field when we were looking to enlarge that field. But even for these smaller retaining walls, we do show the problems that would be associated with accommodating the grade change from the higher to the lower and creating an accessible route. And we've shown how it's not practical given that grade change. And again, those are on page 48 through 53. So if there's additional questions after the presentation, we could pull those up.
That's what I was looking for. Thank you very much.
Thank you. So Ms. Milanovich?
Thank you. So I wanted to take just a minute to clarify something in the DDOT report. We are happy to have their support. We've worked closely with DDOT throughout the project. The DDOT report referenced our original TDM plan that was submitted in December of 2024. However, we did meet with DDOT in January, and during that meeting, we requested flexibility as to the location of the proposed bicycle racks. To be clear, we're not asking for flexibility on the number of bike racks. We're still going to be providing a total of 24 bicycle parking spaces on campus, but we wanted to have some flexibility to make sure we located those in the most appropriate locations where they would be most utilized. And so in that January meeting, DDOT agreed with that, but requested that we modify our TDM plan. Specifically, general strategy number 5 in the TDM plan was updated to indicate that the bike racks would be located in the areas of highest activity where they will be most utilized by students and faculty and staff who bike to work. So that TDM plan, unfortunately, was not referenced in DDOT's report. We have referenced it in the record. It's Exhibit 26C, and that's under Attachment E in that exhibit. And then there's also an email exchange that I had with Eric and Osberg at DDOT, just correcting the TDM plan and documenting his agreement with that updated TDM plan. And that can be found, that email exchange can be found in Exhibit 32A. And with respect to the TDM plan, Vice Chair Blake, to your point earlier about the change in conditions, as Ms. Scheiker said, we holistically replaced the traffic management conditions simply to update those to DDOT's current standards, and that's reflected in the TDM plan. So we've added things like establishing a peak hour trip cap and monitoring plan to ensure that the school adheres to that monitoring, to that trip cap. And so the new conditions, the modified conditions, reflect those changes in the TDM plan to bring those up to what DDOT currently expects for this type of application.
Okay, thank you. So next slide, please. So the next couple of slides just go through how we meet the legal burden of proof. The proposed application does meet the criteria for special exception. That is 203.1M, not 213.1M. And primarily a school is not supposed to be objectionable to nearby neighbors. In this case, our proposed modifications will not create any objectionable conditions. As we've noted, the school has existed here for close to 25 years and enjoys a very positive relationship with the nearby community. And we have placed numerous conditions to ensure that there is mitigation for any adverse impacts. For example, limiting the timeframes for when the lights can be on the field, providing for opportunities for continued work between the neighbors and the field school to address any concerns. Second, we do provide sufficient parking spaces to accommodate the proposed increase, as well as to comply with the requirements of the zoning regulations. The zoning regulations require 124 spaces based on the legal standard, and we are providing 129. Their DDOT does not believe that we need additional parking, nor did our traffic analysis indicate that. Next slide, please. The proposed modifications to the private school plan also meet the criteria in subtitle X, section 104. Again, the use has been permitted and it remains in harmony with the existing uses nearby. There have been no opposition or objections to these proposed expansions. We've talked about how the conditions will mitigate that. We also meet all of the standards of the R1A zone with the limited exception of the retaining walls that we have been talking about. And while not shown on this slide, the application is consistent with the general special exception standard. Specifically, the requested modification will be in harmony with the general purpose and intent of the zoning regulations, which is to protect residential areas and promote a suitable environment for the surrounding school. For the surrounding community. The school's use will continue the education use that's existed for decades, and we believe that the conditions mitigate any adverse impacts. Next slide, please. This is the legal standard for a special exception for an overheight retaining wall. You need to show that conditions relating to the site make compliance unduly restrictive or unreasonable. Next slide, please. As we walked through in our presentation, the retaining walls cannot comply with the terracing or the height requirement and still provide an accessible pathway due to the significant grade change on the site. And again, that was further detailed in the different versions of the studies in the plans that I just mentioned. The retaining walls are located centrally within the campus and will have no adverse impact on any nearby properties, and in fact, aren't visible for many nearby properties. Accordingly, this special exception will be in harmony with the zoning regulations as well, which is to moderate any adverse impact from retaining walls. And then what I'd like to do now, if Mr. Young, if you could please pull up Exhibit 26B, I'm going to walk through the conditions and talk to you about the ones that we are proposing to change and why and how they relate back to the evidence that we have put in the record. I'm assuming that Mr. Young, you're just looking for it right now. Thank you. Okay, thank you so much. So what this chart shows is in the left-hand column, it shows the existing condition from the 2012 BZA order, which is the order that created the conditions that the school is currently operating under. I'm going to go through each of the conditions and talk through them. So the first condition is simply being changed to reference the new construction plans for the addition to the school and for the minor changes to the parking lot and the fields. So that is what that change is. Conditions 2 and 3 reflect the increase in the student enrollment and the faculty and staff, and we've talked about that that is a modest increase intended to be instituted gradually over time. We do not propose any changes to condition 4 or 5. Conditions 6 and 7 are proposed to be deleted. This is because we have expanded the proposed usage of the athletic fields in close consultation with the community. And so therefore, events will be able to start after 6 p.m. given that there will now be field lighting, and we are going to continue to allow, or we are going to allow outdoor athletic events on Sunday, especially with allowing the community to use the field. Next page, please. All right, so conditions 8 and 9 will also be not changed. Condition 10 is proposed to be deleted, and this is because we are trying to reflect the current operations of the site. Deliveries tend to occur during the school day for those that can be scheduled by the school. We do that the school tries to ensure that deliveries would not come during pickup and drop off, but there are deliveries such as Amazon deliveries that cannot be controlled by the school, and so therefore we propose to delete this condition. Similarly, for 11, it is for the waste removal for the trash. That happens based on when the trash company has put us on the schedule, and for many years that has been between 5:30 and 6 a.m. prior to any traffic on the roadways and prior to drop off in the morning. We haven't received any complaints about that, so we are proposing to delete that condition to reflect current operations. And again, I'll note when we get to condition 38, we have put in a fail-safe that if issues arise from any of our conditions, we have a commitment to work to address those issues. In the last decade, we haven't had any issues with this, so we don't anticipate it going forward, but these changes are to reflect current operations.
So, in looking at number 11, would it could also be possible just to reflect your actual usage? So if you're saying the schedules are in the morning, before that, would it be more appropriate to do that? And is it possible that that would have an adverse impact on the neighbors at that hour? You said the experience has been that it has not.
Correct.
At least that's what you're testifying to. So would it be more, I have a hard time removing a waste removal requirement because you have to do it. You have to remove waste and it could make noise and disturb people. I do like the idea of conditioning the time so it's reflective of what you do. It just sounds like the time you do is different than what is on this paper. So that's your decision to change it. So I'd like to maybe, would that have an advert? Would that be difficult to do?
So I think that we could propose a change to this condition to say that waste removal would take place outside of pickup and drop off hours, and that we could put in a commitment to continue to work with the community if there was any issues. There has been no issue raised about trash. And again, this is a change to reflect it, but we could put in there that the school shall schedule, waste removal to take place prior to the morning rush and the drop off and pickup times for the school. I think that was one of the concerns that we tend to see in private school plans. But again, this wasn't talked about at all, and this has been proposed to be deleted throughout all of our work with the community, and no one has raised any issue with it. I'm sorry, I can't hear you.
I'm sorry. In the last modification, this provision was actually put in to address concerns by a neighbor. So that's why I'm trying to get a sense, is that that has been resolved at some level? I'm not sure.
Lori, did you want to address that at all, or?
I would say it has been resolved because there aren't any current issues. And so that's what I would say about that. You know, this is being done at the schedule that the district creates.
So I think that it is that we have limited control over that time, and that it is done prior to drop off, so that there is no adverse impacts to the transportation network, and that we would, we could include a condition that we would make sure that it does not occur during drop off time, because that would cause an issue, because it could cause some transportation backups. So we could change that condition as such. And then again, when we get to condition 38, you'll see that there is that fail safe, that if there was an issue raised, there would be the commitment to work to resolve it.
Okay, I'm going to go back last time on this. So as you're saying now, what time are the actual pickups of the trash currently?
My understanding, and Ms. Milanovic, if you want to jump in, my understanding is it's between 5:30 and 6 a.m. in general.
Yeah, and I would just add, it's part of a larger route. Like the trash trucks are not just coming to the school for pickup. They're making other stops. And so, I think. Sorry, go ahead.
It's a private trash collection company, though. It's not a public service, right?
That's my understanding. Yes.
Right, so it's a private trash company that they can't necessarily dictate the regulations. But okay, thank you. Mm-hmm. Let's move on to the next. So, does anyone else have a question about that?
Mr. Chairman,
Okay.
I just wanted to echo your comments, but I did want to ask Ms. Shaka, is there ever a possibility they could come in the afternoon? I'm just, I want to make sure. I don't want to muddy the waters, but I'm just curious. And then we'll be put in a problem. So I'm wondering. You say 5:30 to 6, which I think is early, but is there ever a chance they may, some may fall through the cracks and they have to come in the afternoon to pick up the trash?
So Chairman Hood, this is one of the reasons why we did propose to delete the condition, because it is outside of our control, given that it is an identified route. And again, also one of the reasons why we talked with the community about putting in that fail-safe provision in condition 38, which says that if any issues come up in the future, we commit to working together to resolve them, because sometimes things change over time. And given this big this is the phased updates to the campus. We don't anticipate coming back to the board for many, many more years. And so we were trying to give ourselves as much flexibility and continue our very strong working relationship with the community. So it is our preference that we would delete this condition or provide language that says this is currently when it occurs, and that we would, that we would ensure that it did not happen during drop off and pickup, because that would be the only adverse impact that really could occur, is if you were having a lot of conflicts and creating backups on the transportation.
But we got all that taken care of, because condition 38 is going to take care of everything that we have a problem with. So thank you. Thank you, Ms. Shaka. Thank you, Mr. Chairman.
So continuing on,
Mr. Vice Chair, might I suggest that we put in a time when the waste will be picked up. I would suggest that we put in language that states the waste removal will take place prior to pickup and drop off, if that's what the intention is. And then paragraph 38 will take care of anything that has to happen outside of those times. But I'm not comfortable removing the provision altogether. At least the community will know that these are the hours when there will be waste removal.
Okay, I appreciate that. I appreciate that, Ms. John. I agree with you that that does make sense to have some provisions around there for that. Okay.
I might just add, if it's helpful, that the trash pickup is actually not adjacent to any neighbors. The trash pickup is actually over. Oh.
You're on.
Where exactly? Where is the trash pickup exactly?
Trash pickup is actually over by the Krieger Museum, part of our property. And so it is not currently, it's not located. It would not be a noise issue that neighbors would be picking up on either.
It's on the north side of the site, which is only near institutional uses. There are no neighbors up on that side of the property. The neighbors are on the south and east sides.
So even if there are no neighbors, I think we need to have a time frame, and that time frame can be adjusted based on the flexibility of the paragraph you propose. That would be my suggestion.
Okay. All right, so we'll continue through the conditions. So condition 12, this at the time of the 2012 order, there was a lot of discussion about whether or not there was going to be outside use of the field. And so there was kind of a situation or a scenario put in place that if we could get support from a certain group of people, then it could happen. We did get that support at that time. So this condition is a bit outdated now. However, in our further work during this process, we have all come to agreement that youth sports and other community groups will be able to use the athletic fields. This was strongly supported by the community given the dearth of fields in this area of the district and the desire to provide more opportunities for students, not just at the field school, to take advantage of these fields. So what we propose to change this condition to specifically state that the school may allow youth sport and other community groups. And we came to agreement with the ANC that information about the availability of the field and instructions for submitting the rental request would be provided on the school's website so that everyone in the community would understand what that process is. So that is what condition 12 does. And again, supported by, you see that as support letters in the record as well as from the ANC. Condition 13 is proposed to be changed just to change those time frames.
Excuse me a second. I want to go back to just on that question there, and not to nitpick, but when you describe other community groups, that's a little bit vague. So I just think it may be worth tightening up that language a little bit because it's not really clear what that might mean.
I think the reason why it was left open is because, for example, the field school might allow another school to use the fields for a home game. It may allow a club sport that is, recreation or a private club to use it. So we were trying to make sure that it was expansive enough to allow for the different groups that we might not know today who needs it, or if there was some other type of community group that wanted to use the field, but then there's going to be instructions on the website about how you request the use of that field so that everyone is aware of how you can do it. So that is why, but we, that's why we had put it that way, is to allow a bit of flexibility going forward.
Now, in that case, though, for example, you've got the school should not allow the athletic field to use for adult baseball. So if one of those community groups wanted to do that, that other condition would prohibit them from doing that. And how would that be different than adult softball, or adult soccer, or any adult sport?
So I'm not sure that I know that there was a concern about the adult baseball leagues, but we will continue to work with the community on the types of community groups. I think that the community wants these fields to be more accessible because of the limited number of fields in the area. I know that Miss Rutherford is on the phone, and on the hearing, and she has had significant discussions with the community about this. I'm not sure if there's anything else she wants to add to that.
No, I thanks for the opportunity again, Sherry Rutherford. Can you hear me? Okay. I just see Commissioner Blake speaking, so I just don't know.
I need you just to introduce yourself for the record.
Sure. So my name's Sherry Rutherford. I've worked with the field school in connection with their community engagement with the ANC and nearby neighbors in connection with this effort. So I spent a lot of time with this ANC. I've worked extensively with this ANC for several years.
representing other schools and universities. So have a lot of experience in this particular neighborhood and other neighborhoods across the district as well. And what I will say is I think, and you can hear this from the ANC commissioners themselves, but there's been a real shift in the understanding of the need for access to high quality athletic facilities for not just independent schools themselves, but for them to, for others in the neighborhood. So it could be, a neighborhood, not a, sort of a pickup, some Frisbee game or things like that, where just an ad hoc community group gets together. They may want to use it for an event. It could be, a soccer team. It could be, again, another school like MacArthur High School has indicated in a desire to play some soccer games there because they don't have their own fields. So there's a very strong voice in the neighborhood for the types of events and types of activities that they really have encouraged and asked Field directly to be able to make those fields available. Now what Field is also doing though is managing that with knowing that we have nearby neighbors that we don't want to be adversely impacted by it. So I think that's what these conditions are trying to, that balance is trying to be struck here, is that we want to make sure these fields are accessible and open to address the need for this kind of activity, but at the same time give Field the opportunity to review these applications as they come in, or these requests as they come in, to make sure the type of activity isn't going to adversely impact those immediate neighbors. And that sort of striking that balance, I think Field's done a great job with so far. It's just that now with this expanded space of time, of availability with nights, with the lights, I think that's where, again, Field just that's where we're headed with these conditions, if that's helpful.
Ms. John, do you have any further questions? I think you do.
I think so. I'm still not sure what community groups would be prohibited. So these groups would be using the fields solely for athletic purposes. Not say, let's say somebody wanted to do a Mardi Gras with a lot of music and all day activity. Would that be allowed?
Well, so
I don't think that was the intent of it, right?
Right. So one of the things, and we specifically spoke to this about with the ANC, for instance, in the evenings, to make sure that there were protections for those neighbors. So something that would draw create a lot of noise or draw a lot of vehicles to the campus that could potentially create an adverse impact for those nearby neighbors. Those are the types of things that we specifically spoke with the ANC. And if you look at those additional considerations that we added when we, to get the ANC support, that was exactly the type of thing. And again, I think Ms. Strauss can speak to this, that we will take those types of events into consideration and making sure that we're not having those types of events occurring in those evening hours when, people are having dinner or putting kids to bed. So, we don't want to have those types of events that are going to draw, too many folks to campus or create those adverse impacts. So I think that's part of that control.
So if I could follow up with Ms. Scheiker.
Yes.
Again, to my question, because there has to be an educational purpose involved in the use of the athletic field. So would this be limited to youth sport and other athletic groups? Or for athletic purposes? I mean, this can't, I don't think this can be a free-for-all. It's a school after all. So
Correct.
I think we need to define what those community groups would be. And I realize that there's been agreement with the ANC, which is wonderful. I just think that that description of the groups can be fine-tuned. And perhaps as we go along, you might think of something to suggest to remove any question as to what types of groups would be allowed. And I realize that the school will provide guidance to the community and on what's available and what times would those activities be available, but the order has to be a little more clear on what's allowed. And we can move on.
So we're thinking about that right now as we continue on. So I'll continue on with the conditions and then we could circle back to that one if we can, please.
Yes, thank you.
Thank you. So condition 13 is to bring this the use closer to 9 p.m. versus the 8:30 p.m., which is consistent with what we would be doing for the outside. And it is to allow use on Sundays. There was no issue with that with the community. There had been concerned about that before in 2012, but the community isn't concerned about use on Sunday. If you could go to the next page, please. This phrase, provided that the same conditions that apply to the school use of the facilities and grounds shall apply to the public. It seemed to be duplicative, so we took it out for that reason, since the conditions now are applying to both the school and any outside school use of the athletic fields.
It's duplicative to which other condition?
So it says, it suggests that there are different rules that could apply. And what we're saying is that all the rules apply to both the community use and the school's use of the fields. So it didn't really provide any additional. It says, provided that the same conditions that apply to the school's use of the facilities and grounds shall apply to the public. We are now specifying what applies to the public, and everything applies to the public and the school. There's no distinction. There's not some things that apply just to the school and just to the public. We weren't sure exactly where that condition had come from. All of the conditions apply to the same use. For example, the lights need to come off at 9 p.m., whether or not it's MacArthur High School using the field or the field school using the field.
Yes, it seemed to me that that's exactly what that provision was telling you to do, was to apply the same conditions as opposed to undo it. I thought that would actually is saying that, so that all that stuff would have to happen, leave the field at a certain hour, not turn the lights on, etc. I think you're saying it's implicit as opposed to explicit. Where is it? Is that right? I said, is that correct? It's implicit, is what you're saying.
That is correct. Can you hear me?
I can now.
Okay, I'm sorry about that. Okay. Yes, that is what I was saying, is that it was implicit in that all of these conditions, it seemed to suggest that there was differentiation, which is not what we were trying to do. We were trying to say that everything does apply. Again, we were simplifying the order for that provision. So continuing on, we have the traffic management section is, as Ms. Milanovich testified to, is being replaced in its entirety with the new TDM plan that was coordinated with DDOT and is in the record and identified in our submission. We did not propose any change to condition 15 because it has always been very important to the community to ensure that only the southern gate is being used, and it is not necessarily talked about specifically in the TDM plan. But conditions 16, 17, 18, 19, and 20 were essentially the previous TDM plan for the school in 2012. DDOT has updated its standard policies and requests for TDM significantly in the last 13 years. And so you can see at the end of this document, we propose replacing the traffic management section completely with the new TDM plan that was supported by DDOT. So next page, please. So for the parking and perimeter section, on condition number 21, the school originally had a maximum number of 128 parking spaces. With the restructuring of the parking lot, that goes to 129 parking spaces, which is comprised of 124 regular and 5 ADA parking spaces, which is what is shown on the plans. Condition 22, we do not propose to change this condition. This is also one of the commitments that the ANC noted in its letter. In condition 23, we
on condition 21, I have a question for you. It is in more. I understand this provision is a little bit different because it says no more than, and it implies a maximum. more recently, we focus on a minimum amount of parking spaces, and then a maximum there is a maximum in it. That's 150% of. But what is the? Can you talk a little bit about the more than versus minimum number?
Sure. So, in when this condition was originally put on, there were concerns that the school would provide too many parking spaces and create additional traffic impacts. And so, the previous order put a maximum number of spaces for that reason. In this case, 124 parking spaces is what the zoning requirement is, and the lot will accommodate 129. Again, the 124 plus 5. So we are identifying that 124 since it is the minimum number, and identifying that we will have 5 ADA. But as we have historically done with this community, we are identifying the maximum number of spaces so that we would not add additional spaces that were not evaluated as part of our transportation evaluation.
And is there separate parking for buses and things of that sort?
That is correct. There is a separate bus parking area that has been relocated. It used to be broken up onto 2 sections of the site. It has now been consolidated in a single section. We could pull up a plan and show you that if you would like. But it is part of the restructuring of part of the bus parking used to be located on the northern side. It's now all located within the confines of the parking facility, which is to condition number 22, at least 100 feet away from the nearby neighbors.
Okay, but the bus parking was never a condition of the order at any point.
No, it was not.
Okay.
And it is shown on the private school plan, and so is incorporated as part of the approved plans.
Thank you.
So again, 22, we do not plan to change. 23, we researched the history of this condition. It came from the original order in 2000. And in 2000, stormwater management and bioretention practices were significantly different than today. We plan to delete this condition because we will be incorporating stormwater management in accordance with best practices. In fact, our civil engineer has already met with DOEE to review the stormwater management and compliance with all DOEE conditions. And so therefore, porous pavement technology is not a best practice any longer. Instead, there are much better practices, and we will be complying with all the stormwater management requirements and working to meet all of DOEE's requirements. There are no changes proposed to 24 or 25. And even though it references in 25 Exhibit 40 in the old record, that vegetative buffer has not changed since that time. So that is why we did not propose to change it. Number 26, at the time, there was a abandoned home that was owned by the field school. And so there was a anticipation that if it was ever used, it would need to have parking provided on the campus. This site at 2207 Foxhill Road is not part of the campus. It is no longer owned by field school. And so therefore we propose to delete that condition since it's not part of the private school plan, and again, not owned by the field school. Continuing on to next page, please. 28 and 29 were improvements that were being constructed as part of the previous project. They have been installed, and so therefore we propose to delete these conditions because they're no longer necessary. However, if they were maintained because there was any concern about taking them out, it just should say, that the school previously, did this. These are just no longer required because they've been done. With respect to the lighting section, as we've talked quite a bit about, lighting was prohibited under the previous order in 2012. In our work with the community and with the ANC, as we've mentioned, there was a desire to have lighting, but to put sufficient guardrails on that lighting to ensure that there were no adverse impacts. And so therefore, we do not change condition 30, which is about kind of the limited nature of the lighting in the parking lot. But with respect to 31, we would propose that the school can have exterior event lighting on the athletic fields in accordance with the plans that we presented. If you can go to the next page, please, you can see the rest of that condition. And this goes on to the negotiated kind of guardrails on the use of those lights, that the school shall turn off the exterior event lighting no later than 9 p.m. daily, and that the school will manage activities on the athletic field in the evening hours to limit noise associated with competition or other events that would draw a large number of people. The school will respond to potential issues, if any, raised by neighbors as to the usage of the athletic field during the evening hours and work in good faith to address concerns. And this language was discussed at length with the ANC commissioners to ensure that if the use of these fields, if there is some type of use that is causing an adverse impact, that we will come together and that type of use won't continue on the athletic field. It is anticipated that the field school's use will be primarily for longer practices. It won't be for large games or tournaments, and so we do not anticipate any adverse impacts from the field school. However, we will make sure that any use by outside groups or youth sports or other schools also don't cause adverse impacts. And then finally, within
I have Mr. Smith, did you have something to say on that?
Yeah, I do, about condition 31.
Mm-hmm.
To say nothing about a fair amount of these conditions, I don't even know if the District of Columbia can really fairly enforce, honestly. I'll just leave it at that. I can't imagine that there's some type of zone inspector that can regulate half of this. But setting that aside, 31, I think that's probably 3 conditions in one, to be completely honest with you about this. I think probably the first 2 sentences is one condition that relates to the school turning off the exterior lighting. That directly relates to lighting. Second is probably one condition: the school will manage activities on the athletic field in the evening hours to limit noise. That's noise. That's not even related to lighting. So that's probably a standalone condition by itself. And the last sentence, the school will respond to potential issues, if any, raised by neighbors as to the usage of the athletic field. And I get the point of the condition. I understand that this has been discussed amongst the ANC and the surrounding neighborhood. But that particular sentence, I think, is probably redundant, considering that you have a condition 38 that speaks to those same concerns in some way. So my recommendation is not to add redundancy into this large list of conditions. I would strike that last sentence because you already have it in essence. So would you be comfortable with, and that would be my recommendation if we were to move forward with this approval, are you comfortable with those changes that I recommended?
So with respect to the putting them into, well, separating the first 2 out, yes, the reason we had put in the second prong about managing activities for the noise for the evening hours is because the lights are the only reason we were allowed to come into the noise, go into the evening hours, and we were trying to mitigate noise. But there is no issue with separating those into 2 separate conditions. As to the removal of the third condition, that would be fine as long as we ensure that it's fully contained within the kind of fail-safe condition in 38, just to ensure our commitments to the ANC continue to be made. And I think that could be done without a problem.
All right, thank you. So I guess we'll talk about that when we get down to 38. So thank you for that.
And then within the lighting section, the final condition is about turning off the lights on the parking lots at 9 p.m. With now the addition of lighting on the field until 9 p.m., we cannot turn the parking lot lights off at 9 p.m. for safety reasons. We also, have not had any issues for the last 13 years with those parking lot lights. They haven't raised any concerns, and it's primarily because there is this 100-foot very vegetated buffer between the nearest homes and the parking lot. And then the types of lights that are used in that parking lot are very low scale lights that just provide safe lighting. So therefore, we are deleting that condition to ensure that people can get safely out to their cars. So that is why that condition was deleted. For the next,
Ms. Shaker, is it possible just to extend that 30 minutes past the field hour or something like that, as opposed to completely deleting it? I mean, I don't think the intention is for for the lights to be on all night or something like that, but to strike it completely would basically render that would make that the case. So you wouldn't necessarily be accomplishing a goal.
we could, as a team, we could find out a time, what is it 9:30 or is it 10 o'clock? What is the time of safety to get everybody out of those fields, and put that the school shall turn off the lights to the parking lots at that time. I think that is probably something fine. I just need to coordinate with my team, and I could respond on that one as well. Since we're not in the same room, but we can, while I finish going through these, I can respond back on that one as well as I am about the community groups and the trash. I have an ongoing list of the ones I said I'll respond back on at the end of this discussion. All right, so the construction management, as I mentioned, we had submitted an updated construction management plan that would relate to the construction of this facility versus a past facility. We have included, without change, all of the previous commitments that that the school committed to in 2012 when it was doing its construction, and those are incorporated in there, and we're not proposing to change any of those. Next page, please.
Before we, Mr. Chairman, Mr. Vice Chair, please.
Please.
So are you asking us to incorporate the construction management plan? I don't know what I missed there.
In the previous order, in the 2012 order, there was a construction management plan that was referenced in the order. We have updated the construction management plan to reflect the conditions for this construction, which are different than the construction that occurred in 2012. And that is in the record at Exhibit 26D. So we were proposing that we would just update that condition to reference the newest construction management plan. And then we maintained all of the specified conditions related to construction that were more general in the order without change.
My proposal would be just to reference the construction management plan as opposed to incorporating it in the order. Because the board cannot enforce the construction management plan. And I recognize that it might have been included as part of the previous order. So that would be my recommendation, Mr. Chairman. And if I could just briefly go back to number 31. The school will manage activities on the athletic field in the evening hours to limit noise associated with competitions or other events. I'm not sure how the school will do that. Ms. Scheiker.
So I'm sorry, if you could ask your question again, I did not understand.
My question was with respect to the noise provision in paragraph 31. How will the school manage the activities to limit noise?
So for example, if there were concerns that a certain type of activity was causing noise, such as possibly we let another high school use it for several games, and they were bringing too many people to the site that was creating noise, we would no longer allow that use to happen if it was creating additional noise. As I said, the field school's use of the field will not be for competitions typically in the evenings. It will be just for extended practice, which has much lower noise and much lower attendance. It's not that you're bringing lots of people from an opposing team. So that is one of the examples that we talked about with the community, since the community does want other schools to have opportunities to use the fields because of the dearth of fields in this area. So therefore, if there were concerns that that type of use was causing too much noise, we would not do that any longer. We are pretty confident that with a 9 p.m. shutoff and the vegetation that's around, that there aren't going to be any issues. And I think that that's generally what the ANC feels as well. We actually had commissioners talk about different fields that were near other people's homes and how they operated. And I think overall, no one is concerned, but we were trying to put in some protections that if someone had an issue, how could the field school respond to address that? And so that's the language we put in as a result.
Okay, thank you. And I wanted to go back to, since I'm thinking of it,
Yes, John, let me just chime in one quick, because I don't want to miss this point on point 31. I think one of the issues too you might think about is to the extent that there may be, you're not going to use the field for competition. So now there's a situation where others may be using fields for different reasons than you, which again goes back to that other element which we didn't address, where we said for the same purposes. So this is a different purpose. The different purpose here now, if it were a competition, would, as you pointed out, attract different elements. So for example, would they be accommodated for spectators? Are there going to be stands for them? How would that work? How would the parking be facilitated for competitive events? Those sorts of things would also play a factor in allowing that type of activity if you didn't prohibit it from competitive things from other schools for that purpose.
Well, if another school was using the field when the field school is not using it, we do have, the 124 parking spaces. We do have the bus parking spaces, and the event would end at 9 o'clock. So it would there is sufficient parking for other users of the athletic field. And again, because the field school will be controlling who uses it, those types of factors can be taken into account.
And if I can make one comment, in terms of the discretion and sort of the field school managing this, knowing what knowing their community and knowing what the concerns are, at a normal, even if it was a competition, a normal lacrosse game, for instance, you may have a handful of spectators that really would have no adverse impact on the surrounding neighborhood. If it is like the city championship game where folks are coming in for, a very high level competition, that's a different story. So I think that's the type of event where just saying no competitive events, it gets tricky because there could be a very, wide range of impacts. And that's where the field school is responsible for managing the level, the events that can take place on campus, understanding that your run-of-the-mill lacrosse game would probably be absolutely fine, but you wouldn't want them to again bring an event that's going to have extensive spectators from across the city that are really going to cause an issue. So that's where, and again, I don't want to speak for Ms. Strauss, but those are the types of things and the conversations we had with both the ANC commissioners who are very interested in bringing these events to, having access to these fields, as well as our nearby neighbors, which are of utmost importance to making sure that their quality of life is not diminished.
And that, I would say, Sherry, also adding to that nothing is changing in our management. We manage the field now. So nothing is changing in how we're doing that. There are additional hours, but all of the systems that we have in place and all of this is the same way that we manage this now.
Okay, so the question, Mr. Strauss, is there a manual or guide that's written down that talks about the management of the field? So in other words, are there some protocols that you have established that you could reference that would say we will, execute this consistent with this protocol that we've established? Do you have something like that?
Yes. And so one of the things we've agreed here too, and to talking with the community, is also to actually put those on our website.
Chairman Blake.
Go ahead, sir. Go ahead.
And, now that I think about this, and I think Ms. John was alluding to this, so I'm glad we returned back to condition 31. And, I think I've kind of alluded to this, or I've said this in other cases, that yes, I understand the nature of why these conditions are created, but if they are conditions, yes, the field school has to abide by them, but it is the task of the District of Columbia to enforce them. So I am failing to understand how you can quantify what is objectionable noise. It is entirely relative based off of what all three of you have just said to me. So how do you quantify that? How does the District of Columbia enforce that? If there's a resident out here, regardless of what is a lacrosse game or some other citywide sport, if there is a complaint from a neighbor that is loud and they complain to the District of Columbia, how does the enforcement agents quantify the noise being loud? And nobody has said that to me.
Board Member Smith, if I could respond to that based on my decades of doing this now, the condition is actually that the field school will work with the community. And so if a person has come to complain to the district, typically what happens is that gets filed with the zoning administrator, and the zoning administrator's office takes it in, calls the Office of Zoning and says, hey, Office of Zoning, somebody has complained that a condition in a BZA or a zoning commission order has not been complied with. And so in this case, the compliance would be, is the field school talking to the ANC? Are they working with the ANC? It's not taking an objective idea of whether or not this is the noise is adverse, because what we're saying is that this condition mitigates any potential for noise under the special exception standard. I do also just want to note that this is not even a full size regulation field. So I believe that the reason why the ANC was so comfortable with this is because it really is just going to provide opportunities for additional practice and game space in the community that doesn't exist today. And I think that possibly getting to, as Board Member John asked us to better define community group, which we're working on right now and have some proposed language, maybe that helps us get to addressing some of these concerns as well.
And I would just add again that we are currently managing this, and we don't have complaints.
Okay, then we don't need this condition if you're currently managing it. And if the nature of the condition is to continue to have some mechanism for dialogue between the community, I think you have that in some way, shape, or form with condition 38. All due respect, Ms. Shiker, I completely respect your years of experience with these types of conditions. I was a zoning administrator in previous jurisdictions. I've seen these conditions, and I understand on the government regulatory side the difficulty of enforcing the type of condition. That's the reason why I raised this. So my recommendation is to strike that portion of the condition and rely on condition 38 for some of these issues that you raised.
And I don't think we have any issue with that, because we believe that condition 38 will provide the fail-safe that the ANC had asked for.
I'm sorry.
I said that we don't have any issue with deleting that element of condition 31, because we believe condition 38 provides the same protection to the neighborhood as we promised.
Or if I might interject, maybe you could say something like, the school will implement procedures to limit adverse impacts from noise during competitions or other events. I would say maybe not authorized, but I'm just kind of thinking this through, but you get where I'm going. In other words, what would be enforceable, I think, would be the activities. I mean, you could identify what the school's action should be. What is the school going to do? Does it have a process? And if the school follows that process, then that might be a way of mitigating noise. I think that's what Ms. Chaika was referring to. So I would just make it a little more specific that there will be something in place which I understand the school has to manage the activities on the field. So maybe something like that. The school will implement a procedure to limit activities that create adverse impacts due to excess noise during competitions or other events. And I don't know what that would draw a large number of people. I mean, that's not specific. I would say authorized by the school, because the school would have a process to say what kinds of events and how large they will be. And I think there is another place where there's a limit on certain events in the gymnasium, which is different. So that would be my suggestion for that paragraph. But I don't want to lose my comment on paragraph 14, because I don't think it's specific enough. It's really laudable that the local residents will be able to use the athletic field. So will that use be limited to the hours between 7 a.m. and 9 p.m. when the lights are off, or when?
If this is in condition 14, where the school shall permit local residents
Yes.
to use the athletic field or to walk or stroll on the campus
Yes.
grounds when these uses are not being used for school purposes.
Yes.
That condition would continue to apply. You know, people can walk through. It's a very wooded, pretty campus is what the
Yes.
intent is. Or, you know, if a family was out on walking around on Sunday and wanted to play Frisbee out there, there's no specific like process to request that. We were just allowing the community to come onto the campus.
Right, but can they walk on at after 9 o'clock when the lights are off?
Well, there's nothing that physically prohibits them, but the lights won't be on, so it would be quite dark and very difficult for them.
Okay, so at any time of day or night, residents could use these facilities.
They are not locked down. That's correct. Yes.
That's what you intend.
Correct.
Okay.
And that's a continuation of the existing use that's happened for the last, you know, at least 13 years.
Okay, that's fine. Some places limit access, but you don't. So at any time of day or night, that's fine with me. Okay, thank you, Mr. Vice Chair. Thank you.
Yeah. One quick question. I want to go back to the construction management. Ms. John, where did you leave on that one, on the construction management?
That it should be
By reference
referenced
is
in
what
the
you're saying?
order, but not included as a specific condition. Because the board can't enforce the construction management plan, but it can state in the order that one exists.
All right, to Ms. Sager, would that be problematic for the ANC?
The ANC didn't have any commitment talked about in their letter as to construction management. It's just something that the field school has always done whenever they've done construction, given that they're in a community that has residential use. So we have put that in the record. I believe that to Board Member John's point, if it is referenced, not necessarily as a condition, but that the applicant proffered a construction management plan, the community would have notice of that plan. And prior to construction, the field school would be meeting with the community to let them know updates on the construction, and will continue to abide by it, even if it isn't a condition in the order. But it was not a requirement of any of the ANC. We just put it in because it has always been in.
Thank you. And the lawyers can adjust the order accordingly. And so that would include numbers 33. Well, 33 is fine. The lawyers would reword that to say the applicants have proposed a construction management plan you know, in exhibit so-and-so, but it would be referenced. It would not be enforceable under the order. And so I assume that items 34, 35, and 36 would be included in that construction management plan, except that 36 could be general, I would think. No, that would include 34, 35, and 36.
Those are, I'm looking at the construction management plan to ensure that they are in here.
If they're not, you can pull them out and put them back in the construction management plan.
All right.
That was all I have, Mr. Chairman, Mr. Vice Chair.
So just, I'm going to just do this really quickly. Back on point number 14, that I still think that portion that has provided the same conditions apply to the schools, facilities, and grounds should apply to the public. I do think that particular phrase, for some reason, to me, does capture what you're trying to do. So I would be somewhat, I like that. I would think that'd be, I'd reference that to stay in. And we can certainly talk about that. Where are we now on our list? We're almost done, I think.
I was not suggesting that they remove it. I was just asking for clarification, and the sentence is exactly what they intend. So I have no.
No, they had initially intended to remove it. So I was suggesting we keep it.
Okay, I'm confused.
This is in 14.
Yeah.
Board Member John, I believe it's our strikeout at the very end of condition 14 that Vice Chair Blake is referring to.
Yes,
the entirety of
I
the
don't
condition.
have, I don't have an issue either way. I was just concerned about what times would local residents have access to the field, and the clarification was that they will have, their access was unrestricted. So I am fine with the first part of that provision, and I have no objection to striking what's left. I think that's implied, but I also don't object to removing it. In other words, I'm neutral on that.
Okay, it's okay. Thank you, Ms. John. Mr. Smith, did you have a comment with regard to condition 31? Did he drop off?
Did I have a comment beyond
where you are now? I mean, I want to make sure we are in the same place in terms of your recommendations and their understanding of that.
My recommendation was to remove the portion of the condition that relates to noise. But if Ms. John has made a different recommendation and trying to craft a better way to be able to quantify that, I'm open to it. I think that was her recommendation. Am I right, Ms. John?
Yes, something,
Okay.
yeah.
Okay, so I guess we'll await Ms. Scheiker making some recommendations to beat that up a little bit.
Where are we now on this list?
We are at the final change in the conditions, which is a change in 38, which talks about maintaining the condition that says after completion of the construction, we'll continue to meet no less than once every 6 months to discuss and review objectionable conditions. And then we've added language that had been requested that we will continue to respond to issues raised by the neighbors when they arise, consistent with the school's past practice of demonstrating responsive and effective engagement with its neighbors, including addressing potential stormwater management concerns. And this is where we could say, and use of the field in the evening. This secondary sentence is really supporting what the condition is, which is that we are going to meet on a regular basis to address concerns. And this just describes what happens at those meetings. So to Board Member Smith's point, the condition is that we are continuing to meet no less than once every 6 months to discuss these conditions, and our commitment to addressing these issues as the field school has done in the past is what that second sentence really is doing, providing guidance to what those meetings are about.
So can I speak to the last part of number 38? And it's also to Ms. John's point of why she's recommending to strike some of these conditions that relate to construction management. Addressing potential stormwater management concerns, that's not necessarily a zoning issue. So my recommendation is to remove everything beyond, essentially in the sentence, add neighbors. And it also gives you additional flexibility to continue to outreach with the community in various different ways, whether that's the school field that you had just referenced, or any other issues that may come up during the life of the special exception itself. So that would be my recommendation. I don't think you need that level of specificity.
Yeah, the applicant would have no issue to that.
Okay.
Thank you.
Mm-hmm.
Ms. John, do you have any other comments or
No, I
questions
don't.
on that last one?
No, I don't.
Okay, Mr. Hood, I haven't heard from you.
I want to make sure, first of all, you know me, and I get where the board is coming from, but when a community comes to an agreement, I know some of this is not, and I would agree with Board Member Smith, some of this is not in our jurisdiction. But one thing that I don't like to do is to undo what a whole community, and I'm sure you all have been around, field schools cases have not been like this. It's been more time with the board than it's been with probably the community. But my issue is I think where field school is, and I may be wrong, Ms. Shiker, is that a lot of this was some issues you all were trying to address from the community to give them a comfort level as you move forward. But on the other flip side of that, I think what my colleagues have been saying is, for me, a lot of this is addressed in 38, and I would wholeheartedly hold 38 in high esteem, because some of the things that my colleagues have mentioned and want to take away, I think can be covered and give the community predictability in 38. So, Mr. Chairman, and I'm going to call you Mr. Chairman today because that's what you are, Mr. Chairman. I don't have a whole lot to say. I just want to make sure that we don't undo what the community and the applicant have worked through, because field school cases have not always been this easy. So I would just suggest that, again, 38, I want to hold that in high esteem, and I'll leave it at that. Thank you, Mr. Chairman.
Thank you very much, Chairman. And I appreciate that, and I agree with you that, and I know that Board Member Smith concurs. We don't want to undo a good thing, but we do want to make sure that we are at least doing things within the context of the regulations that in our purview, so that, and at least we create something that's roughly enforceable document. All right, I think, are we done now with these conditions? I think we are. Are you done with your presentation? It took a lot longer than we ever expected, but are you pretty much in?
We are done. I would just add that our team has been talking behind the scenes, and I could offer, and I'm happy to do it in rebuttal if you'd prefer, responses to the 3 questions that came up with respect to the time frame for the waste. That we would propose that we would say that the waste removal would be done outside the hours of 7:30 a.m. to 3:30 p.m., which would take that waste removal outside of the times of pickup and drop off, but provide flexibility in the future if that time's shifted from what is currently there. We would propose that the lighting in the parking lot go off by 11 p.m. to give sufficient time for safety and for exiting, and just for safety reasons as well. That lighting is very far from any adjacent neighbors and is very, based on one of the conditions, is low directed light. There are no adverse impacts. So if there was a condition to maintain the time the lighting went off on the parking lot, we would say 11 p.m. And then to Board Member John's question on community groups, we could identify it as schools, youth sports, community youth groups, and other educational based institutions to limit it to something more specific. We already have condition 14, as Board Member John talked about the public, who might come out and play Frisbee in the afternoon when the field's not being used. And we do want the community to be able to experience the park-like setting of it when it's not in use. But I believe that that definition for community groups would provide a bit more focus, as Board Member John asked for. And so those would be my final remarks on the conditions. Otherwise, I believe we have discussed and addressed most of the comments of the board on that. And so with that, I'll pause and ask if there are any other questions for me.
Are there any questions for the applicant at this point? We still haven't gone to the Office of Planning yet, incidentally, but we're going to do that next. Are there any questions we have right now, any of the board members on this? Okay, so just what I'd like to try to do is we're going to listen to hear the report from the Office of Planning, and I do not believe an ANC person is here, is there? And we'll see if there's anyone else who wishes to speak. What I'd like to do is, if the applicant could give us a revision of those comments in some concise form, it'd be great if we could do it today, or we could wait and do it in a decision next week. But I think it'd be nice if you could write out, just give us a nice sheet. We have a little time. Worst case scenario, we can hold off, close the hearing and hold off on a decision until after we finish our other cases today. But it would be nice to get your understanding of what we've talked about, because we want to make sure we understand what we all agree to, or what we thought we said. So I think that'd be very helpful if you could pull that together and submit that to the record. Are my board members okay with that?
Yes, Mr. Vice Chair, I'm fine with that.
Okay, great. Let's do that. And so now let's go to the Office of Planning.
Hi, for the record, this is Joshua Mitchell with the Office of Planning. We just want to reiterate that we recommend approval of the requested modifications, as well as the approval of the special exception for the retaining wall. And we would reaffirm the analysis and the comments made in our report. So that's all I have at this time. Open to any questions. Thank you.
Okay, any questions for the Office of Planning from the board? Any questions from the applicant for the Office of Planning?
No, we do not.
Okay. Mr. Young, is there anyone who wishes to speak or testify?
No, we do not.
Okay. Okay, time's up. Okay, so let's see. We don't have that opportunity to pull that together yet. So what we're going to do is we're going to, let's see, how can I do this, Ms. Manhart? I want to close the hearing except for that information we requested for that. I want you to go through and give us a nice clean thing, submit that to the record. I want to reopen this at the end of the day and deliberate and vote on the vote on the application. Would the board be amenable to that? Ms. John?
Yes, Mr. Vice Chair. Alternatively, you could leave the record open for just that one thing, so it's not necessary to reopen the record. That's another option.
Okay, we could do that. Mr. Smith, your thoughts?
I agree with Ms. John.
Okay, Mr. Chairman Hood, you okay there?
I'm fine, Mr. Chairman, but we're going to deal with it today, right?
Yes.
Yes,
Okay.
yes, I think we're going to close the record, and except for that one piece of information which we need, and we're going to reconvene this hearing at the end of the day when we have that information in the file, and we're going to deliberate and vote on this application.
Great, thank you.
Mr. Chair, just to clarify, so are you closing the hearing in the record except for the requested information? Would you like the parties to come back, or are you just going to deliberate at the end of the day?
had the parties come back to discuss the condition. Hasn't come back.
So then it's not, it's a continue to hear it then. It's a
Yeah.
continue the hearing then. Okay, we'll continue the hearing then. That way, in case there are some issues we want to clarify, we can. Okay.
Should we submit the updated document through the record, or should we submit it to OZ staff directly?
You can send it to BZA submissions.
Thank you.
Thank you.
We will do that. Thank you very much. And we will see you back this afternoon.
Shortly, I hope. Thank you. All right. So let's see. Well, I think we're good for now. We're gonna move. Okay, I'm gonna dismiss the witnesses for now. Okay, let you guys go. And I think, unfortunately, I'm gonna need a 15-minute break. Okay, at least that before we go on to the next case. Are you guys comfortable with that, or do you want 30 minutes?
I think it's lunchtime.
It's lunchtime, yeah.
Sounds like a winner.
24.
So let's see. It's lunchtime. We'll be see you back at 1 o'clock.
All right.
Okay.
All right. Thank you.
Thank you.
Back. Okay, Ms. John's back. Let's get started. Ms. Mailer, can you call in start of our session?
Yes, sorry, I didn't hear that before. I wasn't sure if that was for me. The board is back from its lunch break and is returning to its hearing session. The next case is application number 21230 of Washington Area Bicyclists Association. This is a self-certified application pursuant to Subtitle X, Section 901.2 for a special exception under Subtitle A, Section 207.2 to allow extension of regulations applicable to the portion of a split-zoned lot located in a less restrictive use zone to the portion of the lot in a more restrictive use zone. And pursuant to Subtitle X, Section 1002 for an area variance from Subtitle G, Section 201.1 from the density requirements of Subtitle G, Section 201.1. This is for an office use in a two-story detached building located in the MU 3A and R2 zones at 1110 Hamlin Street Northeast, square 3876, lot 47.
Okay, thank you. Welcome back, everybody. Let's see, is the applicant here? If so, would you please introduce yourself and those you might have with you today for your presentation? Ms. Kiker, is that you? Are you who's the applicant? Who's representing the applicant?
I'll start off. Thank you. Can you all hear me?
Yes.
Yes. Good afternoon, Chair Blake, members of the board. I'm Dave Lewis. I'm here with my colleague, Liv Torres, Golson Stores, which is Land Use Council in today's case. On behalf of the applicant, Washington Area Bicyclists Association, or WABA, it's a DC-based nonprofit organization. On behalf of WABA is Elizabeth Kiker, the executive director, and also available on our team for questions is the property owner, Jack Stern, who's also on the web conference.
Great, excellent. I assume you'll be heading the presentation, but I would appreciate it if we could have the property owner and Ms. Kiker both introduce themselves for the record.
Hi, my name is Elizabeth Kiker, and I'm the executive director of the Washington Area Bicyclist Association.
And I'm Jack Stern. I'm the property owner.
Okay, I'm sorry, I forgot. Could you please include your name, your address as well?
Sure, the address of the property is 1110 Hamlin Street Northeast.
Ms. Geiger as well, would you please just give me your address as well?
The current address where,
Your address as a speaker, I just want to get your address on the record.
Yeah, your current office address.
okay, 2599 Ontario Road Northwest, Washington, DC 20009.
Great, thank you very much. All right, I think we also have the ANC representative. Could you please introduce yourself for the record?
Good evening, board. I'm Commissioner Ramin, ANC SMD 5B04 Brookland.
Okay, thank you very much for joining us. What we'd like to do is just kick off the presentation. Mr. Lewis, if you would give us a sense of what the applicant's program is and how you believe that they're meeting the standard for us to grant them approval. Sure. If you have a presentation, I'll put 15 minutes on the clock and you can begin whenever you like.
Should I share my screen or will Mr. Young pull his?
Fortunately, we can't do that, but Mr. Young can pull up your slide deck for you.
Okay, thank you. That's it. All right, thank you. Go ahead to the second slide there, Mr. Young. Just want to start things off by saying that this application involves an existing building on the property at 1110 Hamlin Street, which WABA seeks to use as its new headquarters. It'll be an office use. WABA hopes to maintain its presence as a nonprofit organization headquartered in the district, which it's been for many years now. Mr. Young, next slide, please. WABA intends to use the existing building with only minor changes to the interior and possibly only the addition of an ADA ramp and new bicycle parking to the exterior. There are no meaningful changes proposed to the exterior of the building. Next slide, please. Just a quick note about the property. The existing lot today is very small. About 1/3 of the lot is in the MU3A zone, and the balance of the lot is in the R2 zone. As shown on the map at the left, it's an easy bike ride from the Metropolitan Branch Trail and a short walk to 2 different metro stops on the red line. Next slide, please. Thank you. We are before you today because WABA seeks 2 areas of relief. The first is a special exception under section 207.2 of subtitle A to extend that MU3A zone portion of the lot 35 feet to the west to apply to the entirety of the property. Next slide, please. Thank you. The second area of relief is a variance to allow the FAR for the building to exceed by a very small amount the overall 1.0 FAR applicable to non-residential structures in the MU3A zone. The additional FAR that's the subject of the request is all existing, and the amount by which it exceeds the zoning limit is all in a below grade portion of the building. Next slide, please. And just to reiterate, the exterior of the building will not change. This is not a demolition or a raise in any way. The existing building is going to remain. The existing footprint is going to remain. So just wanted to make sure that was really clear up front. Next slide, please. Thank you. We're very happy to be here with support from Commissioner Amin and the rest of ANC 5B, support from the Brooklyn Neighborhood Civic Association, OP, no opposition from DDOT. We have a support letter from Councilmember Parker and more than 24 neighbors. And note, just briefly, a typo on the slide, it's ANC 5B, not ANC 5D. Apologies for any confusion there. But this application is before you with robust support, and folks are very excited for WABA to be in the Brookland neighborhood. So at this point, I'll turn the presentation over briefly to Elizabeth to talk a little bit about WABA and its mission and why this property is really uniquely well situated for WABA's mission, because that's such an important part of our justification for the requested relief. So Elizabeth, if you go to the next slide, and then Elizabeth can talk through WABA briefly.
Thank you so much, Dave, and thank you, Council, for hearing our application. WABA was founded in 1972, and we work in Washington, D.C., as well as in Virginia and Maryland. We work to promote bicycling, walking, and transit in the entire region. As you all know, when you cross a jurisdiction, you don't stop driving or stop biking. You have to keep going to wherever your destination is. We have been located in Adams Morgan for 15 years. The long-term goal of our organization has been to buy. I actually spoke with a board member yesterday who said, gosh, we have always struggled to find a place that meets all of our needs, but we wanted to buy when I was on the board 15 years ago. So it's been a long time. And the former executive director said the best time for Waba to buy would have been any time in the past 50 years. But so we can go to the next slide. The work that we do is sort of three prongs. We really work strongly with advocacy. We're working to make sure that in Washington, D.C., Maryland, and Virginia, there are safe places for people to bike and walk and take transit. We really focus on protected bike lanes and making sure that planners are using bike lenses as well as driving lenses. We organize community members around bicycling and safe streets. We build strong relationships with decision makers, and then we work with allied groups. A lot of our work is with lots of partnerships to show how vital transportation investments are. Next slide. We also do a lot of education work. We do that in the entire region, Prince George's County, Montgomery County, Arlington County, and Fairfax County, as well as DC. We have a contract where we teach in DC public charter schools programs throughout each year, reaching lots of students, and we're teaching children how to ride and also how to ride safely. So there's and then we also teach youth and adult classes, again, both how to ride and then how to ride, with traffic and on the streets and on the bike lanes that we have now. So we reach thousands of people that way each year. Next slide. And then we have this great program called the Trail Rangers, which is supported by the DC Department of Transportation, as is our education program. And the Trail Rangers, I wish they were in Virginia and Maryland too. They do work. They're really, I don't know if any of you have seen them, but they're amazing. They go out on all of the DC trails and keep it cleared. So they cut down branches, clean up tires. You know how people will dump tires? They clean out 30 or 50 tires a day. They clean invasive vines. There's an invasive vine clearing this coming Saturday. And then they have coffee hours and just talk with people on the trails too. So it's a really neat program. Next slide, please. Thank you. And then we just opened a community bike shop called Gearing Up, which is the continuation of a 10-year tradition that existed in Washington, D.C. It was a separate organization that fell on hard times and was not able to succeed, but WABA bought its assets and kept it going. So people donate bikes to Gearing Up, and then there's youth that come and take classes and learn how to repair bikes and then earn a bike, get a free bike themselves. And then if they're interested, they stay and learn how to run a bike shop, learn how to be a mechanic. And then we also do a service where people bring their bikes and we fix them, or if they donate bikes and we sell them. So it's a community bike shop, and it is right next to Alethea Tanner Park. Next slide. So the location, as I mentioned, we've been looking for a very, very long time, but the trick is that I would show you the office I'm sitting in right now. I show you a blank wall, but the rest of it is just boxes. And there's a tiny window you can see right there.
That's okay. We can't do live testimony. You shouldn't do live testimony. Just head on. It's fine. Thank you.
I'm sorry, I apologize. So I think here we're more focused, the current location is more on the bike parking side than the human side. So we have a lot of bike parking needs, both for our trail rangers and our education programs, as well as the staff that bike to work. And so our current offices are sub floor, basement, and it's hard to find a place that there's a lot of property in DC, but it's hard to find a place like law firms have a lot of space now, but they don't want trail ranger bikes with chainsaws and tools, parking in their lobby. It's not. And so the thing that we really love about Hamlin Street that we were so excited about and are so excited about is that there is the basement entrance fits the trail ranger bikes, fits the education bikes, fits a lot of the bikes that we need to store, and there's a lot of light and a lot of windows for the offices and the staff for the rest of the team on the second 2 floors. And I apologize for turning the camera around, but that's why we are so excited about Hamlin Street. And I believe that's the end of my presentation.
Thank you very much.
Yep. Go ahead. One more slide, please, Mr. Young.
Oh, I'm sorry. And we didn't need, the proximity. I forgot to say the proximity to the trail is so vital because at this point, our staff have to come from where they live, many of them in Northeast or elsewhere, to Adams Morgan to get their bikes and then go back to the trails to maintain the trails, or they ride here. And so the proximity to the metro and the trail is amazing. And we're just very excited about that opportunity as well.
Thanks, Elizabeth. Next slide, please, Mr. Young. So as I mentioned, there are two relief requests in this application. I'll run through the standards for each quickly after Elizabeth has talked through kind of the public interest mission of WABA. The first area of relief is a special exception, which includes 4 prongs under section 207 of subtitle A, and then the 2 under the general special exception standards of subtitle X, section 902.1. So running through those standards quickly, under section 207.2A, the property is exactly 50 feet wide per the 1925 plat that created the lot. 15 feet of the lot is in the MU3A zone and per the zoning, and then the balance 35 feet is in the R2 zone. So the zoning regulations permit extending the less restrictive MU3A zone 35 feet to the west, which lines up perfectly with the entirety of the lot in the R2 zone. So we satisfy that first prong. The second prong, section 207.2B, does not apply here. That section applies only when the R2 zone is the less restrictive zone, which is not the case here. Here, the R2 zone is the more restrictive zone. Next, under sections 207.2C and 901.2B, I grouped them together. They're similar. They go to adverse impacts on nearby properties or the neighborhood generally. And as evidenced by all the support in the record and from our written statement, this application is not going to have adverse effects on the neighborhood. Under section 207.2D, there are no conditions necessary for this use at this location, so that item is also NA. And finally, under subtitle X, section 901.2A, this application is in harmony with the intent and purposes of the zoning regulation. It allows a small-scale office use along the mixed-use corridor in Brookland. The height and density of the building are as they are today and in line with what is allowed in the R2 zone. Next and final slide, please, Mr. Young. Thank you. Under the second area of relief, the applicant seeks an FAR variance to use the entire building for office headquarters use. The MU3A permits a maximum FAR of 1. The existing building, which predates zoning, very slightly exceeds 1.0. It's 1.045. That's entirely on the basis of a portion of the building, the basement, counting as GFA. The applicant would like to maintain the existing building as is, and would like to use that basement area as part of its operations. As Elizabeth testified, it would be used largely as the trail ranger storage and kind of, correct me if I'm wrong, Elizabeth, but I think the trail rangers would have space down there where they would meet and, and work together, that sort of thing as well. So it'd be very difficult to remove that basement space from the building or exclude it from the C of O for the office use, which is why we're seeking the variance to continue that space. So quickly running through the variance standards, there are a number of factors that make this property unique, including its size, lack of rear yard, but most importantly, location of the zone boundary in the pre-zoning age of the building. These are more fully identified in our written statement and in the OP report. These unique factors together create a practical difficulty in complying with the FAR limit of the zoning regs. And as this board is aware, you all may be more flexible when applying the standards for a variance to an applicant that serves the public interest, as WABA does, and where the relief goes to the applicant's public interest mission, as is the case here. Here, the FAR relief is necessary to allow for that bicycle storage and tool storage, and for the bikes that are used for educational purposes as well. All of that is directly related to WAPA's public interest mission. And finally, the final prong of the variance relief goes to adverse effect on the neighborhood again, and not impairing the zone plan. And as mentioned in the special exception standards, again, the relief here really is not at all inconsistent with planning or with the zoning regs or frankly the zoning map for this site. So, so at this point, we'll wrap up our direct presentation and take any questions that the board or the ANC may have. But just want to say thank you again for your time. Really appreciate the opportunity to present this afternoon.
Okay, thank you very much, Mr. Lewis. Do we have any questions from the board? Do we have any questions from the ANC to the applicant? Okay, I'll then turn over to the Office of Planning, please, for your report.
Good afternoon, board members. For the record, Shepard Beeman with the Office of Planning. LP has reviewed the application for the requested special exception relief for a zone boundary crossing and requested area variance from FAR and finds that the request meet the criteria for subtitles A and X. As the applicant proposes no changes to the existing building, the proposed nonprofit office use should not negatively impact the surrounding context. The applicant encourages alternative uses for mobility and discourages the uses of cars. The existing building located on a split zone parcel creates a condition that limits the property in terms of use. Considering the building exceeds the maximum FAR for both the R2 and MU3A zones. Therefore, OP recommends approval. As stated on the record, OP will also note that since this is a self-certified application, OP reviewed the requested relief submitted by the applicant. However, should it be determined that the applicant needs additional FAR relief during the permitting process, OP does not object to the granting of additional relief if needed. And with that, I can take any questions.
Does anyone have anyone on board have questions for the Office of Planning? Does the applicant have any questions for the Office of Planning?
No, sir.
Okay. Mr. Shepard, I have a quick question for you. Mr. Beam, I have a question for you. If you had mentioned something about additional FAR, do you mean if they wish to use more of the lower level space, or what exactly are you referring to?
So again, those calculations that the applicant provided were based on a previous case. So we weren't sure if that was actually the correct amount of FAR needed for that this specific property. Considering that it is split zoned and looking at the regulations, it may be interpreted for this case that it may need additional FAR relief during the permitting process. But again, OP does not, object either way, but it's not OP's responsibility to interpret the zoning regulations.
Okay, I understand. Mr. Lewis, do you have any comment on that, or?
No, I understand Mr. Beeman's comment, and I appreciate OP's support. My understanding from both this board and from the zoning administrator, we have not spoken with the zoning administrator for this case, but in the past, she has interpreted 207.2, 207.1 to have the more restrictive zone adopt the FAR limits of the less restrictive zone, which is what we're talking about here. The R2 zone is more restrictive than the MU3A zone. So the 1.0 FAR will apply to the R2 portion of the site. If the R2 was less restrictive, for instance, and the neighboring site, or the zone boundary was R2, R1, there is no FAR for the R2 under the zoning regs. So the zoning regs say in the R2 zone, the FAR is 0.4. We don't think the 0.4 is applicable here at all. We think that the FAR for the R2 portion of the site is going to be the 1.0. So that's our understanding from the zoning administrator's past actions, and frankly from the BZA's past actions involving relief of this sort. I think what Mr. Beeman is saying is if the ZA changes her mind and says that the FAR for the R2 portion is actually 0.4, then we would need additional FAR, and OP doesn't object to that additional FAR.
Okay, well, I can have the other board members comment on this, but I do think that the measurement is not our responsibility either. It is the ZA will make that determination, and if this is a self-certified application, so to the extent that you do have to revisit it, it will. And I think we probably could focus on the questions for us based on the information we have. Any other board members concur or disagree with that?
I don't disagree. It's a self-certified application.
Okay. All right. Then let's see, Mr. Young, we have no other questions? Mr. Young, do you have anyone that wishes to speak?
No, we do not, other than the ANC.
Oh, I'm sorry. Thank you very much. Mr. Rahman, I apologize for doing that. Please.
No problem, Chair Blake, and good afternoon again, Chair Hill, Hood, Chair Blake, and board members. I did prepare a few things to say, but for the sake of time, I do not, and I can go straight to some key points that I just wanted to make. Again, I'm the ANC Commissioner, and I've been authorized by 5B, my colleagues, to speak on this. The Brooklyn community and ANC 5B, as well as me as the SMD representative, we've conducted a pretty extensive and extended community engagement process. There have really been no real oppositions or concerns that have not been able to be addressed by the ANC or the applicant, and we're very, very pleased with that. This project has become very, very important to the Brooklyn community, and there's a lot of support behind it. One of the main reasons that it is very, very supported here is because it's very important that we revitalize historic 12th Street in Brooklyn, and we feel like this project alone, WABA coming into our community, moves us closer to that goal that this community has been working on for many, many years to bring life back into historic 12th Street. And as well as just the work that WABA does in the community, they've already proven to us they're going to be good neighbors and good partners along the way. We can already see the benefits of this WABA possibly coming into our neighborhood. Zeke's Coffee will be opening up on 9th and Girard in our neighborhood next week. So this is really exciting for us because this is what we've been working for as a community. And, and with all that being said, on behalf of ANC 5B and the Brooklyn community, SMD 5B04 and Ward 5, I want to ask the board to support this applicant on this request here. And thank you for your time, and I'm happy to answer any questions from the board or the community.
Mr. Rahman, thank you very much for your ringing endorsement. I appreciate that. It certainly does sound like the community is really excited about this and wants it, and I'm overwhelmed with your enthusiasm. Does the board have any questions for the commissioner?
Mr. Chairman, I too want to echo your comments about Commissioner Rahman. He and I work together in other capacities, but we appreciate, and I want you to know publicly, I appreciate all the work you do, Commissioner, and continue to keep doing the good job you're doing for the community. Thank you.
Thank you, Chair.
Okay, all right. Thank you very much again. All right, now, Mr. Young, is there anyone who wishes to speak?
Not.
Okay, so Mr. Lewis, do you have any comments that you would like to close with?
Just very briefly, thank you to Commissioner Amin and Mr. Beeman for the support on this application, and thank you to the board for your time. I'll just keep this very brief. We think this application is set up to move forward. As noted, we have lots of support from ANC, OP, DDOT, neighbors, etc. No opposition. This application is directly in line with the special exception criteria and satisfies the variance test, especially when the board applies the public interest standard laid out in the case law. So we thank the board and the agencies and the community members watching for your time and consideration. Thanks so much.
Thank you. Okay, I'm going to dismiss the witnesses. And I guess we can be in deliberations if everybody's prepared for that. Let's see.
And I think, Mr. Chairman, you wanted to close the record and the
Oh,
hearing
yes,
as well.
sorry about that. Thank you very much, Ms. former Vice Chair John. Thank you. Please do. Would you please close the record so we can deliberate this and move on. Okay. So let me see if I can find my notes. That's what I was actually looking for. I believe that the applicant has met the burden of proof to be given to grant the relief. Reviewing this, it's clear that the special exception to extend the height and bulk into the standards MU3 to the R2 zone, they've met the criteria for that. And we discussed it particularly with the leeway granted through the nonprofit status. I think that it's a very interesting building because it is residential in appearance, and they don't intend to increase the size of it, which means it will have the same appearance as a residential unit going forward, even though it would now be considered in the M3 zone. I'll be honest, my major concern with this particular thing is that as you extend the zone, you do extend also the other development standards with it, and also some of the matter of right use standards that go with the MU3 zone, which would be fairly inconsistent in some regards with the R2 zone. However, in this particular instance, we are looking at an office use, and it's going to be an office use by a not-for-profit organization that is actually outside focused. I mean, they're on the trails, they're doing stuff outside, they're not in there carrying on and doing a whole bunch of stuff. So the reality of it is the nature of this and the nature of the office use does make this, I think, not so detrimental to not problematic for the neighborhood and creating some adverse impacts. So that said, I do believe granting relief would be in harmony with the zoning regulations. And I would be in favor of the application, in favor of approving the application for an office use in this as part of that to accommodate an office use. So we would incorporate that in the caption. Mr. Smith.
I couldn't say it better than myself, Chairman Blake. So I don't think I have anything to add. I agree with everything that you've stated regarding this case and will support the application.
Thank you very much, Ms. Johnson.
I'm in support of the application as well. I'm going to give great weight to OP's analysis of how the application meets the standard for the area variance. And again, I'm in support.
Thank you, Chairman Hood.
Yes, Mr. Chairman, I would agree with my colleagues as well as with the record. I think everything that's been said, I think warrants our approval. I think this record is complete and ready to move forward, and we'll be voting in support. Thank you.
Thank you. Having deliberated, we move to the vote. I'd like to make a motion to approve the application as read and captioned by the secretary for an office use, and ask for a second, Ms. John. I'm sorry, Ms. John, you're on mute.
Thank you. Yes, I am in support of the application, and I would second based on how the application is read and captioned.
Okay. Having second, Madam Secretary, would you please take a roll call vote?
Please respond to the Vice Chair's motion to approve the application. Vice Chair Blake?
Yes.
Ms. John?
Yes.
Mr. Smith?
Yes.
Chairman Hood?
Yes.
Staff would record the vote as 4-0 to 1 to approve application 21230 on the motion made by Vice Chair Blake and seconded by Ms. John.
Okay, thank you. Madam Secretary, would you please call our next case?
Next is application number 21234 of the DC Department of General Services. This is an application pursuant to Subtitle X, Section 901.2, and Subtitle C, Section 1312, for a special exception under Subtitle C, Section 1305.2 from the height requirements for building mounted antennas of Subtitle C, Section 1305.1. This is for the relocation of building mounted antennas from one building to another on a university campus. It's located in the R1B zone at 4200 Connecticut Avenue Northwest, square 1964, lot 812. As a preliminary matter, there is a request from the applicant to waive the filing deadline for supplemental filings in the record exhibits 25 through 25G.
Okay, if there's, I have no problem admitting that to the record. If there's no objection from our board, I'd like to see that information. Okay, hearing no objections, we should do so. Could you please, if the applicant is here, could you please introduce yourself? Mr. Gregory? Mr. Gregory, are you having trouble with your device? Let's see in two places. Mr. Young, can you help him or? Let's give him a couple minutes to figure it out here. Mr. Young, can you help Mr. Gregory?
Yeah, I would advise him to call the hotline number if he's having issues, and he can call in by phone.
Gregory, Mr. Gregory, if you can hear that, would you please call the hotline number? It's on the screen. I said it earlier. I can't see it though because something's in front of me. Oh, 202-727-5471.
It says, but now I am. Bye. I apologize.
Ah, there you are. Thank you.
Yes.
Welcome.
So I was only now able to unmute myself.
Okay, well, welcome. Would you
Yeah.
please introduce yourself for the record?
Yes, good afternoon, members of the board. My name is Phil Gregory. I work for the Department of General Services. In this case, applicant for the special request.
Okay, your voice is not coming through very clearly. There's some breakup. Also, are you able to use your camera or is that using up too much bandwidth?
I can hear you fine. There's an echo, but I can definitely see all of you on my screen. But I
Can you
don't know why.
can you use your screen itself? Can you?
Sure. Let's see, integrated camera. Oh, there I am. Oh, thank you. I'm not sure. There you go. Thank you.
Okay, there you are. Great. Okay. Well, I'd appreciate it if you would introduce yourself for the record first.
So my name is Phil Gregory. I work for the Department of General Services, the applicant in this particular request for special exception.
Okay. Do you have anyone else with you today?
So online, I am joined by the Office of Unified Communication, Tadesse Solomon, who manages all public safety radio sites around the district. I am also joined by Dwayne Kinley with Motorola. Motorola, as you know, is the radio operator for the district. And I am finally joined by Eric Cole, who provided all the drawings and filed the permits for this particular project. And here is Dwayne joining us here.
Okay.
And Eric Cole is also there. Mhm.
Okay, thank you. Just Mr. Gregory. Mr. Young, did all of these people sign up to participate?
I do not have them on my witness list, so I would check with the secretary to make sure they're sworn in.
No, we just have Mr. Gregory for this case.
Okay, so if we, should we call them to have, should we just, if they call for testimony, we can just admit them for that? They've done the affirmation, the oath, right? That's done.
No.
No, if they have not signed up, then they did not take the oath.
Okay, so should do that. Can you just, to make it simple, can you just administer that?
Sure. If you all would please raise your right hand. Do you swear or affirm that the testimony that you will give today is the truth?
Yes.
Okay. You may consider yourself under oath.
Very good. Thank you.
Okay, so just to simplify matters. Okay, now, Mr. Gregory, would you please, you have 15 minutes on the clock, if you take a minute to go through and tell us a little bit about the project and how you believe the applicant's meeting the burden of proof to be granted?
Absolutely. In fact, I do have a presentation, Mr. Young, if you could please pull that up. Thank you. Thank you, Mr. Young. All right, so this particular project, if you could please switch over to the next slide, is for the relocation of a public safety radio system within the UDC campus. You will notice in the picture here that Building 41 was the site of a Motorola public safety radio system for the past 22 years. With Building 41 on the right-hand side of the screen, going through the abatement process and soon to be demolished to make way for the archives building, a new location for the radio site was identified in Building 38 on the left side of the screen. That particular building requires a number of antennas for the reception and the transmission of public safety radio signal. And if you could please turn to the next slide. Thank you. And the purpose of these antennas are essentially to make sure that there is a clear communication between first responders and the district 911 and 311 center. We have these antennas in place essentially to provide that centralized coordination of all public safety voice communication with the Office of Unified Communications, 911 Center, 311 Center, and of course, first responders. So this particular radio site ensures that it serves the need of the community. Next slide, please. Just to give you an idea, on this particular slide, you will see 4 quadrants. The one on the far left corner shows 10 dots. These dots, each dot represents a radio site. On the upper left-hand corner, middle dot is the UDC radio site. You probably notice how the communication is solid because of the UDC radio site. Whereas if you switch over to the next quadrant, if we were to remove the radio site from UDC, from that particular quadrant of the city, you would completely lose communication from an exterior portion of the building. In fact, the green area that you see here illustrates a radio gap or signal gap in that particular area. Now, likewise, on the third quadrant, the UDC radio signal allows first responders, if they were to communicate inside the building, to have a clear signal as they communicate back and forth with their headquarters, with the call center, 911, 311, and any other law enforcement agencies. Now, if you were to remove that particular radio site from UDC, and I'm referring to the last picture on the right, you probably noticed the green area. That green area shows a complete gap in the radio signal by not having that particular radio site at UDC. Okay. If I could please look at the next slide. Thank you. So what we're requesting, Chair Blake and members of the board, is a special exception from these building mounted antennas under 1305.1, .2, 1312, and 901.2 to install 4 9-foot panel antennas in the area that you see on the picture. So these antennas will be located inside the screen wall, away from any public view, insofar as the mounting equipment and hardware is concerned. The antennas will be seen, of course, above the wall, which is why we're requesting a special exception. Likewise, the 220-foot Omni antennas, which will be used for reception, will be installed above the wall, but with the mounting hardware inside the 10-foot parapet or screen wall. So these antennas, as we will see in the next slide, were required a permit, and so we had to file 2 separate permits with the Department of Buildings. The first permit was to allow the installation of the 220-foot antennas, or what we call the Omni antennas, or WIP, or reception antennas. And the second permit was required to install the 4 9-foot panel antennas. These panel antennas are required to transmit radio signal from the building and to surrounding areas. Next slide, please. All right, so let me focus a little bit on this particular aerial view of a UDC. What we're going to do here, and if you look at the center of the screen, there is a rectangular shape, highlighted in yellow, a sliver of real estate where the radio antennas are installed. These antennas are on the building 38. And what we're going to do right now is essentially illustrate how the presence of those antennas throughout the area around UDC does not present any issues insofar as the visibility is concerned. So what we're going to start with first is on the right-hand side, you probably notice a small number, 01, and we are going to go counterclockwise around the picture with specific vintage points where photographs were taken directed towards a building, and you will see that in some cases antennas are visible, and in other cases they are not. So if I may please take a look at the next slide. So this particular shot here, the building 38 is in the background. The shot here was taken from Vizzy Street at the intersection, of course, of Vizzy and Connecticut Avenue. The antennas can be seen because the 20-foot antennas actually, protrude above the parapet wall. But I should point out, members of the board, that these pictures were taken, I guess, at the best possible time to make a case endpoint, right? Because the leaves are down. This is probably the time of year where you would be able to see the antennas. But as you can see, because of the distance, but also because of the material used in constructing these antennas, they're rather discreet. Next slide, please. So this particular picture was taken from Connecticut Avenue with a clear shot of the building. You can barely see the antennas from across the street. In fact, the picture was taken catty corner from the Starbucks, which is in the UDC campus area. Next slide, please. So this particular shot was taken from Wyndham Place with a clear shot of building 38. As you can see, we cannot really see those antennas, even though, of course, there are no leaves on the tree. But if you were to, really get a close up of the picture, you would see part of the two Omni antennas. Next shot, please. Next slide, rather. So this particular picture was taken from the side of building 41. Building 41 is the building on the right-hand side with a clear shot of building 38 straight ahead. You can barely see the antennas, but we know they're there because we installed them. Next slide, please. So this particular shot here was taken from the intersection of International Drive and Van Ness. You may recognize the ramp to UDC. So between the ramp of UDC and the building on the right, you probably took note of the Omni antenna on the left-hand side and two panel antennas on the right-hand side. So this particular vantage point is really useful because it allows you to see firsthand what you would be seeing if you were to stand in this particular spot. Next slide, please. So in this particular slide, we're now back on Connecticut Avenue, right across the street. There is a antenna that shows up on this particular picture. It's one of the two Omni antennas that we mentioned. And finally, the last slide of the pictorial. Thank you. So this particular picture here was taken right smack in the middle of the UDC plaza. You have building 38 in front of you. Building 41 is in the back. You probably took note of one of the two Omni antennas in front of you atop of the rooftop and a couple of panel antennas on the right-hand side. So the Omni antennas are facing north while the panel antennas are facing west, and we're now looking east at the building. Next slide, please. All right. What I'd like to do right now is to go over the burden of proof discussion and share with you why we believe we meet the test for a special exception approval. Next slide, please. Right. So going through the various regulations that pertain to 13051, 13052, 1312, and 901, we checked every single regulation and are able to respond. If we could please start with the top of the antenna, it has to, it cannot extend above the top of the wall. In this particular case, of course, as the drawings showed, they do extend above the wall for a very specific purpose, which we'll go over in a minute. But as a result, of course, we respectfully ask that you, give us an exception from this requirement, as we will continue to discuss below. So the antenna installation shall be located or a screen such that its visibility from public spaces, etc., is to the greatest practical extent limited. Well, you probably noticed in the a series of pictures that we took that the antennas are actually minimized to the greatest practical extent, as their unobstructed heights are required for the sole purpose of transmitting and receiving a radio signal, which are a critical communication between first responders, the 911 center, 311 center, and of course, other law enforcement agencies. Finally, in this particular regulation, the nature of this particular application is really for and only for the mission critical nature of this installation. These antennas are identical to the antennas that were and still are and will be removed on Building 41. Those antennas, as I pointed out, were installed back in 2003, and they predate the 2016 regulation for regulating antenna heights. Okay. So again, I just want to point out that the existing antennas on Building 41 will be going down as the building itself will be demolished under a separate project. It's going through the abatement process right now. The next regulation that we also reviewed and considered for this particular request for a special exception is the type of material that was used for the construction of the antenna. Well, if you notice in the pictures, the material used and the colors used were used in such a way that they blend in with the skyline. We did not, notice any glaring a contrast against the sky. And as you know, the pictures that were taken were actually taken, as I mentioned, when all the leaves were off the trees. And so this was a perfect a time to be able to illustrate how discrete, as much as they can be discrete, these antennas are. The next regulation that we also looked at was the building-mounted antennas had to be placed on the penthouse or a rooftop structure with a rooftop outdoor space, which is secured. Well, the good thing about Building 38 is that the rooftop only has the communication devices or equipment to support the radio site, which is actually on the third floor of the building. So unlike Building 41, which had a shelter on the rooftop, this particular building actually has its own mechanical room where the radio site is actually installed. So when you make your way to the rooftop, the only thing that you see in terms of radio equipment are the antennas, the two omnis, the four panels, as well as what we call a doghouse for cable management going down to the third floor. But when you stand inside the rooftop, you're actually surrounded on all three sides by a 10-foot screen wall or parapet. Okay, and above the parapet is where those antennas extend. The next regulation that we looked at is the shelter. As I pointed out, the nice thing about Building 38 is that the shelter does not exist since we actually have a specific room where the radio equipment is installed. Next slide, please. Okay. So in this particular case, what we looked at is the map of the area that is being served for the new antennas. So the transmission and the reception of those antennas provide communication throughout the northwestern part of the district. And they serve, as I pointed out earlier, a specific public safety radio communication. Last but not least, the regulation requires a map indicating the location of any other antennas. So if we could please look at, let's see, the next slide. Oh, no, let's go back to the previous slide, please. So the map of the areas, you may have seen during the presentation that the Office of Unified Communications maintains 10 radio sites throughout the district. Now, there are other antennas within a 2-mile radius. Those antennas do not belong to the Office of Unified Communications. We checked with the Office of Department of Buildings and do not have a record of what antennas or who the owners of those antennas are. I can tell you that if you were to look west from Van Ness, you will probably notice at the intersection, more or less, of Nebraska Avenue and Van Ness, NBC News is out there, and there is a tower. That tower is there for the purpose of commercial carrier communication with NBC, but and it is within a 2-mile radius, but it does not. But it does not form part of the OUC radio site farm. So this concludes my presentation and the discussion, and I'm of course hoping that based on our presentation, we will have demonstrated that it meets the test for the special exception approval by this board. Thank you for your time.
Thank you, Mr. Gregory. Thank you for that very thorough presentation.
Thank you, sir.
Is there anyone on the board that has any questions for the applicant or any of those with him? Okay, let's turn to the Office of Planning. Spires, would you please introduce yourself for the record? Oh, Joel, how are you?
I'm well, thank you, Mr. Chair. Thank you. Joel Lawson here for the Office of Planning. I'm sitting in for the far more antenna knowledgeable Aaron Thomas on this case, who's not able to be here. But I will note that OP has recommended approval of this case. Our report is in the record at Exhibit 26. And if you have any questions, I can try to take them. Thank you.
Thank you. Does anyone have any questions for the Office of Planning? Does the applicant have any questions for the Office of Planning?
Well, I would only add that the ANC voted unanimously 6-0-0 to provide a letter of support in favor of these public safety antennas.
Thank you, Mr. Gregory. That is in the record. Okay. Mr. Gregory, is there anything else you'd like to add before we close?
I do not have any other items to discuss, Chair Blake. Thank you, sir.
Okay. Well, thank you very much. So I'm going to dismiss the witnesses.
I just, sorry, Mr. Chair, I just didn't think you asked for public testimony.
I did not. We don't, but do you have any public testimony? My apologies. Thank you very much, Mr. Young.
We do not.
Do we have any public testimony?
No, we do not.
Okay, thank you very much. All right, so now we'll dismiss the witnesses and move on to deliberation. Okay. Now see how the chairman gets gassed at the end of the day. Anyway, this is fun. I'm in support of the application. As the applicant explained, there simply are no options to reduce the height and achieve the desired coverage for 911 service. The pictures provided in Exhibit 29 and on the applicant's presentation certainly showed that the view would not change appreciably from what is currently exists due to the proposed projections above the screen and walls, and the whips would be minimally visible from Connecticut Avenue, if at all. So the proposed installation should not adversely affect the use of surrounding neighboring property as it already exists within the neighborhood, and the complaints have not been received regarding operation or visibility. So I credit the applicant's presentation and the Office of Planning's analysis of how the applicant has met the burden for approval. I agree with the Office of Planning's analysis and give great weight to its recommendation for approval. I also give great weight to the report of the ANC 3F, which is in support and states no issues or concerns. Mr. Smith, do you have anything you want to add?
No further comments. I'll be in support as well.
Ms. John?
Thank you, Mr. Vice Chair. I think you covered everything and I'm in support.
Mr. Hood?
I would agree, Mr. Chairman, and I want to thank Mr. Gregory for his very thorough analysis and presentation.
Okay. So if I neglected before, I want to close the record in the hearing. Having completed deliberations, I want to move to the vote. So I'm going to make a motion to approve the application as written and read by the secretary, and ask for a second, Ms. John.
Second.
I have a second. The motion's been seconded, and I'd ask for the secretary to take a roll call vote.
Please respond to the chair's motion to approve the application. Vice Chair Blake?
Yes.
Ms. John?
Yes.
Mr. Smith?
Yes.
Chairman Hood?
Yes.
Staff would record the vote as 4-0 to 1 to approve application 21234 on the motion made by Vice Chair Blake and seconded by Ms. John.
Okay. Madam Secretary, would you call in the next case?
The next case is application number 21235 of 5058 Central Ave Trust. This is an application pursuant to Subtitle X, Section 1002 for a use variance from Subtitle U, Section 201 to allow a flat in a semi-detached two-story with basement building. It's located in the R2 zone at 5058 Central Avenue Southeast, square 5286, lot 837. And in Exhibit 24, the applicant submitted a request to waive the filing deadline to submit a response to the OP report.
Oh, great. Thank you, Madam Secretary. I'd like to make sure we get all that information into the record. So if it's okay, I would like to submit that those late filing. Would the applicant please introduce himself? Ms. Hartley, I believe. You're on mute.
Thank you. My name is Cynthia Hartley. Address is 1511 Neal Street Northeast, Washington, D.C. 20002.
Okay, Ms. Hartley, thank you very much for being here today. We reviewed your case. Obviously, you have in front of us what is going to be a use variance. It's a relatively high standard for relief. Essentially, in a use variance, it's determined that the application you want or the use you like is something that the zoning commission has determined is not appropriate for the zone. And if however, you're able to demonstrate a particularly unusual circumstance related to the property, or a combination of factors and issues that lead to an undue hardship, which is also a very high standard, and there's no issue with the intent of the regulations, or that you're not really having an adverse impact on neighboring properties, the applicant, we can grant you relief. So as again, it's a very high standard. So with that, I'd like for you to begin your presentation. We'll put 15 minutes on the clock, and you can begin whenever you like.
Thank you. If you could please bring up the PowerPoint that I submitted. Let me scroll over to the clock so I can keep an eye on it. Okay, so this is a very unique situation because this is something that actually took place in 2017. So we're talking 8 years ago. So next slide, please. Yeah, in 2017, I submitted a building permit, or in 2017, I secured an architect to do some renovations on a house. I bought a property on Central Avenue, and I secured the services of Ojai Engineering, to an architect and engineering firm licensed in DC, because I wanted to convert the basement into a one-bedroom apartment. Ojai, and as you can see in this is the building permit that was granted. It's a 2-unit flat granted by the what was DCRA at the time, submitted by Ojai Engineering without any conditional restrictions. If you can go to the next slide, please. And next slide after that, please. So this is a timeline of events, and as you can see, it goes back to 2016, 2017. So I also secured the services of Paul Wharton Construction Services, a general contractor licensed in DC. The next slide, please. Is that it? Yeah, and so I think that's the next slide. I apologize. I'm a little confused and nervous. So in this email here, we see Ojai Engineering is communicating with DCRA to say that we are that the intent is to obtain a certificate of occupancy because it's not going to, essentially, it's not going to be owner occupied. At the time, I was not aware of the difference between a 2-unit flat, a single family house with an ADU, and no one could explain it to me, and no one had explained it to me until last year. So, and I'll kind of get to that point. Next slide, please. Again, that's the building permit. Next slide, please. And that's the contract I had with Paul Wharton Construction Services. Next slide, please. And then in turn, Mr. Wharton secured the services of a third-party engineer licensed in DC, Charles Mobley and Associates, to, third-party inspector to do all the inspections. And he submitted the mechanical, the plumbing, and the electrical inspection. And the next slide, please. And he also submitted the final inspection, all while under the permit of a 2-unit flat. Next slide, please. Shortly after the final inspection, the general contractor began the process of trying to obtain a certificate of occupancy, and I gave him the name of the LLC to which the C of O should be under. Next slide, please. And he followed up with me the next week to say that I didn't need a C of O. I did question that. I said, I think all rentals need to have a C of O. And then I said I was going to go to DCRA. And when I went to DCRA, they too said I didn't need a C of O. And I tried to get an understanding as to why. And he just said, you don't need one. And so I said, okay, fine. Next slide, please. So everyone was on board with the conversion and the building permits were issued. So I want to fast forward to 2023 when I wanted to put solar panels on the roof for the tenants upstairs, and there was a delay in permitting. So I was told that there was a zoning issue from 2018, and this was, of course, well after everything was done, because this is now 2023. And so around this time, I revisited the C of O issue. Next slide, please. And as you can see from the message on the portal, it says a C of O is not required, but here it says a single family house with an ADU. Now, at this time, again, I didn't know the difference between the two. So I went down to DCRA at this point, and I spoke with Mr. Calhoun, who was the person who reviewed the C of O request. And he explained to me what had happened. And when I explained that I had a permit for a 2-unit flat, he said the permit was issued in error, and he suggested I discuss this with the zoning administrator, Kathleen Beaton. And she said there was nothing I had to do. I have to come here for relief, and she wrote the relief memo. So as I'm working to resolve the permitting issue with the solar panels, I was told that zoning approved the building permit for next slide, please, for a single family house, which is in this letter. He says, as you're aware, they approved a building permit for a single family house with an ADU. But as I already pointed out, I received a building permit for a 2-unit flat. And again, I didn't know the difference. I just went forward with knowing that it was never my intention to live in the house. So 2 weeks later, next slide, please, I received another email from the Board of Zoning stating that they're correcting the building permit from 8 years ago. So now they're making it a building permit for a single family with an ADU, and that the building permit was issued in error from 8 years ago. The next slide, please. And then this is a snapshot from the Department of Buildings Scout database, where it shows that in 2018, I can't see it, it's a bit small. Let me see if I have a copy, but I think you might be able to read it, where it says in 2018, here it is. That they issued the permit was issued with an incorrect scope of work that reflects a use that's not allowed by zoning regulations. But this is something that they realized after the fact, after I did the renovations, after I went to the expense, and after I rented out the units, and I was never informed that there was a mistake. So the next slide, please. So now I know why all of this time I could not get a certificate of occupancy. It was because DCRA at the time made an error, and this has caused me exceptional difficulty and hardship because I am not able to obtain a certificate of occupancy. Because I can't get a certificate of occupancy, I cannot get a business license. Without a business license, I cannot register with the Department of Housing and Community Development, and therefore I essentially have no legal standing. And I've at this time, I've experienced a personal financial loss of well in excess of $10,000. Next, because a tenant is not paying rent. But all of this happened after I started this. So it's not as if I started to do this because the tenant stopped paying rent. The tenant stopped paying rent after this ball was already put into motion. So the next slide, please. So these, had I known from the beginning, had DCRA said to me, no, you have to do a single family house, had they just said, we cannot give you a building permit for a 2-unit flat, and had I understood the difference, I would have said, okay, well, I'm not going to do the extensive renovations that I did. I converted the basement. That was the basement before on the top picture, and this is the basement as it looked after the renovations. I dug out the basement an extra foot. I installed twice the appliances that I had to in the house. I have twice the HVAC units, 2 electrical panels, 2 sets of plumbing and everything. I also had to do some additional structural issues in terms of widening the back stairs to make it into the meet compliance for the basement requirements. So all of that costs quite a bit amount of money. So there was definitely financial hardship there, financial investment that I'm now experiencing hardship because if I can't keep it as a 2-unit flat, which was the intention all along, then I'm good. Excuse me. I'm going to have no other choice but to sell the property. The next slide, please. So it's either move in or sell the property. If I sell the property, I'm going to displace the tenants that are there. The upstairs tenants are a very lovely couple. They've lived there since 2017. They have 3 children that have been raised in that house for the longest time, and they've expressed to me that they want to stay. The other option is for me to move in, which I don't want to do because I've been living in my house here in Trinidad. I've been living in this neighborhood for 15 years. Um, I have a community here. I would be displacing the tenants over there anyway. And I actually rely on my house as an additional source of income because my job was reduced from 40 hours to 20 hours last year. So I've been pet sitting dogs on Rover to supplement my income. And that's something I can do at this house. I would have to give up my entire clientele and start building a new clientele all over again. The next slide, please. So I don't believe that there is any detriment to the public good, and I did get a unanimous letter of support from the local ANC. I met with them on several occasions, including the community organization. The house from the outside, nothing has changed. It looks like every other house in the area, on the streets. The original footprint of the house wasn't expanded. The only thing that's different is the use inside of the house. And I would actually say it's positive for the public good because it's a safe home, it's affordable, it's energy efficient, and even more so now that I put the solar panels on the house. And the next slide, please. I think this is the last slide. Oh, that was the last slide. So this is a very unique case because everything that happened 8 years ago. And I get that at the time there was it wasn't clear as to what the difference is, with a single family house and a 2-unit flat. I understand that they had just changed the codes at that time and the city made a mistake. But now, it seems like I'm being penalized because of that mistake because I tried to do everything that I was supposed to do. And There was a mistake. It was beyond my control, and I do believe that's an exceptional situation that has caused me hardship.
Okay, very much. Thank you, Ms. Hartley, for your testimony. I have a couple quick questions for you on just just to clarify a couple things, and then we'll move through to the Office of Planning and other questions for the board and then the Office of Planning. When you purchased the building, did you intend to live in it, or did you intend to make 2 units and then rent them out?
It was going to be to have 2 units and rent them out. It was not my
And
intention to live in it.
and the real estate professional that sold your house indicated to you it did not it sold it to you as a single family house though.
It was a single family house. Yeah,
Okay. And so you undertook the renovations yourself.
I did. Yeah.
Okay.
In
And
consultation with an architect and engineer, general contractor,
you
third
had
party
the
inspector.
investment professionals there with the real estate professionals there, right, right. But did you apply, what did you apply for when you actually applied for what did you apply for? We don't have a copy of the documentation for your application, but what
The
did your
building
application actually say?
the building permit was for a 2-unit flat. That's what the architect put down. When I met
The
with them,
architect
they
put
said,
that there.
yeah. They said,
Okay,
"Oh, you want a 2-unit flat?" And I said, "Yeah." I
okay,
honestly didn't know the difference. I just thought it was a matter of semantics. Single family house with an ADU, 2-unit flat.
okay. And you're saying that none of the real estate professionals you hired could tell you the difference between the ADU and the flat?
Not only did they not tell me, but no one at DCRA that I spoke to could tell me the difference
Okay, right.
between a 2-unit flat and yeah. It wasn't until last year when I spoke to Mr. Calhoun that he explained it to me.
Okay, all right. All right. Do you have any other documentation other than the permit that stated this was a two unit flat? I mean, you said use the permit as your primary document.
Yeah.
Is there anything else? Was there anything else that you got that would say that?
Well, I tried to access uh, project docs. And I tried to access project docs from a while ago. That's the system that they use for the whole building permit process to see if there was anything in there that I could get. And for some reason, I no longer have access to that. I emailed the department um, several months ago, a couple of months ago, saying, "Hi, I can't access project docs." And somebody just followed up with me yesterday saying, "Do you still need this?" And I said, "Yes, I still need access to project docs." I can pull up her email, and I don't remember it off the top of my head.
Okay. So I think I have a pretty good handle on what's going on in the timeline. Does anyone else on the board have any questions for the applicant?
I do right quick, Mr. Chairman. Ms. Harley, I get your professionals like the real estate and whoever sold you the house and your architect. But you continued on. I'm trying to make sure I understand the story. You continued on, uh, also relying on what the information the government gave you as well, proceeding down those same lines. Is that a correct assessment or statement?
I continued based on the building permit. Yeah.
So what they gave you, that's what you relied on.
That's what I relied on. Had I not been given a building permit for a 2-unit flat, had they said, "No, you cannot have a 2-unit flat," I would have switched gears. I would have asked, "Well, what's the difference?" And then I would have said, "Okay, well, if I can't do it, I can't do it." I wouldn't have gone through all of this, the duration, the period it takes to request a use variance. I would have just renovated the house as a single family house
Right.
without doing the renovations in the basement and building it out. I wouldn't have gone through that expense.
Okay, I got it. Thank you. Thank you, Mr. Chairman.
Okay, thank you, Mr. Chairman Hood. I'm going to now turn to I'm sorry, Ms. John. I'm sorry, please.
Yes, Ms. Hartley. So was there a building inspection done?
Yes, there was by Mr. Mobley, the third party inspector, Charles Mobley.
Okay, and
I think his name is Clarence Mobley.
Clarence, I'm sorry. Yeah, I'm
Clarence.
looking for my notes here. Clarence Mobley. Yeah.
okay,
So
is there
the
an exhibit with that? building inspection?
In the PowerPoint slide,
Uh-huh.
there, one of the slides shows a copy of the final inspection submitted by Mr. Mobley. The slide right after the mechanical, electrical, and plumbing is on one slide, and then the final inspection is on the next slide.
Okay, and about what date was that?
That was August 14th, 2017.
Okay, let me see if I can pull that up. I wasn't able to read it on the slide, Mr. Young. Let me see. Okay, so I see mechanical and final inspection. I'm looking at slide 8. I don't see zoning.
There was
George Worsley, scope of certification, mechanical final, electrical final, plumbing final. That would have been August 14th, 17.
Yeah.
My computer is doing strange things. Building final. Okay, it has the permit number there. And was the basement complete at that time
Yes.
with
yes,
all
ma'am.
of the changes?
Yes.
Um, Okay, I don't have any more questions at this time, Mr. Vice Chair.
Okay, thank you. Let's see, Mr. Smith, do you have anything you'd like to ask at this point? Okay, I'm going to turn now to, oh, I should ask, yeah, I'm going to turn now to the Office of Planning. And Ms. Myers, I'd like you to introduce yourself for the record, but also I'd like to, after that, to actually go in a little bit of detail with regard to the requirements behind a use variance, specifically talk about what is required, and then talk a little bit about the applicant's application in relation to that.
For the record, Crystal Myers with the Office of Planning. Unfortunately, in this case, the Office of Planning is recommending denial. This is because, as mentioned earlier, the use variance test has to be met in order to support an approval. And in this case, the Office of Planning does not feel that the test has been met. The criteria for the use variance is for there to be an exceptional situation resulting in an undue hardship to the owner. And that situation has to be related to the property or to the building itself. It also, there has to be no substantial detriment to the public good, and there has to be no substantial impairment to the zoning regulations. In this case, back in 2017, the Department of Building issued a building permit for the property, and it includes a scope of work description that says the house is being converted from 1 unit to 2 units. In order to get a full picture of what happened in this case, OP reviewed the applicant submitted emails with Department of Building and talked with the Department of Building staff. Though the staff person who originally issued the 2017 building permit is no longer with Department of Building, OP was able to discuss this case with current DOB staff. Department of Building acknowledges that the scope of work on the building permit is not clear. In their email to the applicant, they state that at the time there was confusion on how to represent accessory units. Back in 2017, accessory apartments were relatively new to Department of Building. They did not have a clear way of representing them in building permit, and at the time it was sometimes their practice to describe them as single dwelling houses with accessory units as 2-unit houses. And I understand from the applicant that their team is the one who reflected it as 2 units. But again, Department of Building kind of looked at it as being kind of interchangeable at the time. So when the permit was issued, Department of Building discussed with the applicant's team that this second unit could only be used as an accessory unit. So Department of Building at the time had always, at least my understanding is that they had always understood it as being a single family house with an accessory unit. It's just that how that was described is where the confusion comes in at. And so when it was issued, they had discussions with the applicant's representatives that this was an accessory unit and it can only be used as an accessory unit. This is why a certificate of occupancy permit was never approved. A certificate of occupancy is needed to rent out 2 principal units. It is not needed for an accessory apartment, which is why the applicant's team was told that a C of O was not needed. And I believe the applicant was also told by her team that a C of O wasn't necessary. But I believe her team told her that. If Department of Building had intended to approve this as 2 principal units, then they would have also completed the process of the certificate of occupancy and approved that permit as well, but it was not done. I know that an application was submitted, but along the way, it was figured out that this was just an accessory building and the C of O was in error. So although OP sympathizes with the applicant's situation, OP does not consider this an exceptional situation. The misunderstanding appears to be mainly between the applicant and her development team, but not with Department of Building. Similarly, in regards to an undue hardship to the owner, OP does not consider the applicant's hardship to be from an exceptional situation related to the property. And this is why OP did not feel that that first prong of the test had been met. And essentially that is why the rest of the test was unable to be met as well. OP does understand that when it comes to substantial detriment to the public good, it would perhaps not be a substantial detriment to the public good to grant this. But when it comes in regards to impairment to the zoning regulations, we do feel that there would be an impairment to the zoning regulations. Granting the requested use variance would be contrary to the intent of the zoning regulations for the zone. No exceptional situation leading to an undue hardship to the owner has been sufficiently identified on the property. Furthermore, the integrity of the zoning regulations could be seen to be eroded if this relief were granted, particularly since the regulations specifically provide a conforming option for a second unit, which is an accessory apartment. That would meet the intent of the regulations and address the applicant's goal to provide a second unit on the site. With that, I will conclude the OP testimony, but of course here for questions. Thank you.
Thank you very much. I do have a couple questions for you. Do you know in what time frame, and I know the applicant had kind of talked about this, what time frame was the C of O applied for? Do you have a sense of that?
I believe it was 2017 or I know that I think the applicant purchased the property in 2016. So somewhere between then and I guess when it was approved, you said the certificate of occupancy.
Mhm.
My apologies. I believe that was somewhere in that 2017, 2018 range timeframe,
And
but
it
I'm
was
not sure.
denied.
I think it was just out there. I don't even think it was completed. I think it was pretty determined that it wasn't necessary, so they didn't finish the process.
Now, are there any public records available that would give us uh, an indication otherwise, or of how this whole thing unfolded beyond? I mean, the story you told me about, the development of the recording at the uh, Department of DCRA at the time, was a little disappointing. But could you tell me if is there any other paper trail that we could have that could help us in public records that might piece this together so we can have a better sense of applications? The applicant didn't have any other documentation.
Unfortunately, I'm not aware of anything more. I mean, maybe there's a C of O application, but nothing that was completed. And I don't have access to anything more than what is in the record.
Okay, all right, thank you. Does anyone else on the board have any questions for the Office of Planning? Yes, sir.
So just for clarification, so you know, a lot of this hinges on some of this discussion that you said that you had with DOB. So this discussion that you said that you had with DOB, is that written down somewhere, or is that just a conversation you had with the zoning administrator and the zoning administrator staff on this conversation that happened between the applicants, contractors, and DOB staff?
Yeah, it was a verbal conversation as well as the applicant's emails. That's in the record. One of the inspectors, I believe, is who she had communicated with, who had reflected some of the information that I also heard from the folks that I talked to at Department of Building, specifically about how the scope of work description was intended to be about an accessory apartment, but it was unclear and confusing on how it was described in there. But the inspector specifically said that it was intended to mean for us an accessory apartment.
If I may, that would have been Mr. Rohan Reed, and that would have been an email that he sent to me last year when I started this whole thing unfurled, if you will, and I was trying to get the permits for the solar panels. And as he's trying to investigate what's going on, he sent an email saying, as you know, you were approved for a building permit for a single family house with an ADU. And I'm like, no, that's not, I didn't tell him that back and forth. I say, no, that's not the case. I was approved for a 2-unit because I have the building permit. He sent a follow-up email a week or two later stating that the building permit that was issued to me was issued in error. And it was just last year is the first time that I'm hearing of this, that DCRA made a mistake. I shouldn't have been issued a permit for a 2-unit flat. It should have been a single family with an ADU.
Okay, I have a question, Ms. Myers. Do you have anything from the public records that would give us an indication of whether that permit was surrendered or revoked? There's obviously a process you'd go through to get to that point. If that permit was found to be in error, then they would have gone through and issued a notice of revocation and requested surrender. Do you have anything in the record that would support that?
I'm not aware of it being surrendered or revoked. My understanding, and I think this was in the email actually, is that it was just left pending because it just wasn't completed. I think they were saying that there need to be another step or two done, and that was not done when it was realized this was completely unnecessary. But if it was revoked or withdrawn or anything along those lines, that may be true. It's just not something I was aware of.
So if I may again, Mr. Rohan, he had an inspector come out to do he said there was not a final inspection that was done, but as we saw, there was a final inspection that Mr. Mobley did in 2017. So Mr. Rohan said that he has to send an inspector to come out and do a final inspection. And he did send somebody out, and that's when they were able to do to lift the issue and saying, okay, we did the inspection for an accessory apartment, but this wasn't a situation of an accessory apartment. The final inspection was done for a 2-unit flat. Now they're doing an inspection for an accessory apartment last year. So that's why I don't know why, but that may have been why it was pending.
Chairman Hood, you had a question, I believe.
I just want, and Ms. Myers, you may not want to answer this. Maybe I'll leave it to the legal folks. And I'm going to use a word that I hear all the time over the years: detrimental reliance. If I throw that word out there in this situation, what would you respond, or do you have a response if I use those words?
Don't have a response. I mean, all I can do is tell you what the information that I have from the emails and the little bit I know from the conversations that I've had with DOB staff. And unfortunately, the original DOB staff member who was more involved in this case is no longer at DOB.
Okay. I do remember some of the years ago about the conversations about AU, which is not germane to this situation. And I know the city and the commission and zoning, and we're all trying to get it together. So I was around for some of that. So thank you. Thank you, Ms. Myers. Thank you, Mr. Chairman.
And if I may, I forget what slide it's on. I can tell you in a moment. It's the slide that says where Mr. Reed mentions that the permit was issued in error. It's in that same email that he discusses exactly what we were talking about. I'm following up to inform you the review of the inspection information is complete, and it confirms the maximum gross floor area of the accessory apartment is not being exceeded. Further, OZA has confirmed they approved the building permit block B 1702150 for a single-family dwelling with an accessory apartment. Based on this information, the zoning administrative hold has been removed from DOB's permit system to allow further processing of the solar permit application. So the hold that might have been in place was the hold might have been there from the beginning, or from 2018 is what I think it was when I looked at the Department of Building Scout website. It looks like there was a hold placed in 2018 and saying to that I need to turn a permit in, but nobody ever emailed me, nobody ever called me, nobody ever sent me a letter. The only time I found this out is as I'm looking for information related to this, and I came across that on the Scout website.
Thank you very much. Ms. John, Mr. Smith, do you have any other questions for either the applicant or the Office of Planning? Okay.
I have a question for the Office of Planning. I don't know if you can answer, but I'm going to ask it anyway. So there was a final inspection for mechanical and some other things, electrical. If there had been a final inspection for zoning, shouldn't there be some record of what zoning did at the same time? I know, I mean, I think now there is such a cheat sheet because I've seen it at DOB. So everybody checks theirs off, and the last group that sees it is zoning and I believe HPRB. So do you know what the process is now?
I don't. I'm, I work for the Office of Planning and not the Department of Building, and so unfortunately, I don't fully know their processes.
Yeah.
I will say that the one thing that has been told to me a few times from them is that you need a C of O in order to rent out the 2 units, and a C of O was never approved on this case. And so for them, that's sort of why they would say, like, that's just always been the process. And that was communicated to the applicant's representatives. And so that's what we kind of based our decision and position on, is the fact that that's been a constant, and in this case, it was never given. But everyone acknowledges that there is confusion with the building permit, and so we understand 2017, that was right when the ADU were really coming into being, and so there was still a little bit of confusion on how to represent them on building permits, but the C of O, that has been a constant.
And I can appreciate that it's been a constant, and it's my understanding as well that you need a C of O for a rental. And in an email from the general contractor, unfortunately, he's no longer around, he said that the property would not need a C of O, and all I have to do is complete the business license application, pay the fee, and you're all set. Bring your LLC registration documents and walk it through. All the inspection finals are in the system. No on-site zoning inspection required. You're good to go. And in my email to him, I said, it's my understanding that since this is a rental and not a primary residence, I do need a C of O. However, I'll head down to DCRA tomorrow morning to follow up. And I went down, and again, they said, you do not need one. Not that it was rejected or denied, but you don't need one. And they never gave an explanation as to why I didn't need one or the difference between a single family and a 2-unit. They just said, you don't need one. And so I just said, oh, I guess I don't need one. Maybe if DCRA is telling me I don't need one, general contractor is telling me I don't need one, and everyone else is telling me I don't need one, then I'm thinking, okay, I don't need one.
Okay.
Ms.
Okay,
Hartley,
thanks.
just as a follow-up to that question,
Here's going, here's
oh, I'm sorry, Mr. Blake.
No, we're going to go to the same place. Go ahead, go ahead, Mr. Rodriguez.
Did you, we'll see. In that conversation that you had with the with DOB, and you had this, it sounds like you had this conversation, well, at DCRA, when it was DCRA at that particular time. Did you follow up with them with an email or a form of determination that it sounds like you intended for this to be a rental unit? Did you follow with them to see if you could get it in writing, especially given this being up in the air, and unclear even between them and your contractor?
No, sir, I didn't. I presumed that DCRA knew this was going to be a rental because in an email from the architect, she said that that there was going to be a change of use, and I will be applying for a C of O. So, but again, this is something that I wasn't aware of at the time. It's only something that I'm aware of now as I'm looking through emails and trying to find, trying to piece together what happened 8 years ago.
Okay, gotcha.
What I'm wondering is if, so you do not need a C of O for an accessory dwelling. And I believe that also means you could rent it out and would not need a C of O. The problem is when you have 2 principal units and you rent those out. There may, again, there sounds like there was confusion for multiple things here. But, our position is that it seems like the correct communication, at least verbally, was between the Department of Building or DCRA at the time and your team did not correctly explain things to you when it comes to you don't need a C of O because it was an accessory unit, or at least that was how everyone understood it.
Yeah.
Okay.
And I'm not sure who one might
Excuse me,
have.
Ms. Hartley, let me see if I can help this a little bit here. So, I mean, that's obviously, unfortunately, there's a lot of hearsay involved in what we're hearing on that part of it, which is concerning. It'd be ideal to have some documentation through emails or otherwise to make that work from that perspective. Ms. John, I think you have something, a question. If not,
I don't have a question. The the description of work on the application stated a conversion from a single family dwelling into 2 units flat. That's coming from Mr. Reed. So this is probably deliberation, so I can wait to make those comments.
okay. Before we close the hearing, I want to know, is there anything that the board needs that would help individuals with this analysis and this decision? Is there any additional information that anyone might need?
I mean, short of information from DOB, I can't think of anything. I mean, what did the application state? What did the scope of work state? Are those documents available? You know, we don't know what's in the record from DOB, except for the oral testimony of Ms. Myers. And they admit to confusion about how to identify scope of work for an accessory apartment as opposed to a flat. So I don't really know, Vice Chair or Blake.
Okay, that's good. Mr. Smith, you don't need anything else?
I agree, Ms. John, short of DOB pulling up the emails from this previous employee that's gone. I don't know what we can ask for here. So no, I don't think I need any additional information.
Chairman Hood, do you need anything else that might help you?
I saw the timeline, but to me, that timeline, I'm just as confused as they probably were in 18 or 17. That timeline, they helped me, how she just spelled it out. We did this, if I saw it visually, and maybe I'm missing it, of who did what, who was on first, who was on second, who told who what. For me, that would help me out, other than me trying to go off my recalling what I just heard. So that's just where I am. Thank you, Mr. Chairman.
Okay. All right. So I'm going to do this real quick, a little bit different. I'm going to do this real quick. I'm going to ask I'm going to close the hearing. No, my next thing. Are there any people who wish to testify? Mr. Young.
No, we do not.
Okay. Ms. Hartley, do you have anything that you'd like to add at this point? I'm not saying you, I'm gonna close this down for a second and speak to the board in deliberations. Is there anything else you have that you like to say?
The only thing I would add is, I mean, I don't know the definition of hardship, other than it would certainly cause me hardship to have to sell this house. All of the work, all of the time I've put into it. It would cause me hardship to have to move into that house just to keep it. And it would cause the tenants hardship to have to displace them, whether I sell it or I move into it. I don't see where anyone would win in that situation.
Okay. Okay. Thank you very much. So I believe with that, I'm going to close the hearing and close the record. And I'll dismiss the witnesses.
Thank you.
And I'm going to move to deliberation. Now, in doing this, we indicated that there may be some pieces of information that would be helpful in making this decision. I'm not clear that there isn't enough information currently. And so, because I have no idea where people are on this. So I would like to go through deliberations. If we find that we're not in a position to make a decision, then I would feel very comfortable getting that additional information. And if we're in a position to make a decision, I'd like to do that. So, Mr. Smith, would you like to kick this off?
I don't even know where to begin and how to kick this off because again, this is there is a lot of hearsay on what has on some of the discussions between DOB or DCRA, the contractor, and the applicant in question. I can discuss about some of my findings based off of what I heard today, and also the staff report. So, what I've in looking at the information presented by the Office of Planning, and looking at the three prongs, I can see how they arrive at their approach for the three prongs. But again, for the first prong, as far as what's the word I'm looking for? This exceptional situation. The Office of Planning bases the exceptional situation on, to me, it sounds like some discussions that they've had with DCRA. Now, what I'm concerned with, and I, will use the term that Chairman Hood has said, detrimental reliance. I can arrive at the applicant detrimentally relied on DOB's description or DCRA's description on their building permit. When the zoning commission permitted accessory units within zones that only previously allowed single family uses, I think it was incumbent upon DCRA to make that clear on their permits. And in this particular case, they used a use that would not have been allowed. So I think they should have modified their permits to provide that clarity. So I think, and because they didn't modify their permits, I think it created an issue for everyone in the approval apparatus and the entitlement apparatus to have this large degree of confusion. So I do believe that there was some measure of detrimental reliance that could lead to exceptional situation. So I'm, I would like to hear from my other board members regarding that approach to the first prong. With the third prong, I think that I agree with the Office of Planning that it may not rise to a that I do believe that it would be contrary to the intent of the zoning regulations. So within the R2 zone, the regulations do grant option for conforming second unit as an accessory apartment. But however, again, I think there's a case of detrimental reliance on how that permit was issued. So currently right now, I don't quite know where I'm at. So I would welcome like some additional dialogue from my fellow board members on their reading of the prongs.
Okay, I'm going to go to Ms. John next.
So I was of two minds about this, but I think I am leaning towards what I would call reasonable reliance on DOB's evaluation and description of the permit. Was it reasonable for the applicant to believe that she was authorized to build a 2-unit flat? And I look at the description of work again, it says interior renovation and conversion from single family into 2-unit flat. Doesn't say anything about an accessory structure, accessory unit, including mechanical, electrical, and plumbing. So the zoning designation is there, 2-unit flat, doesn't say anything about an accessory structure. And there's also a new basement entry. And again, proposed use is flat 2-family. Existing use single family. And then the email that admits that there was confusion in how to designate how to describe a single family unit with, a building with a principal dwelling and an accessory dwelling. And that's in the email. So, I mean, what do we do with that? If DOB was confused about how to evaluate these applications at that time, since everyone has had more experience with the regulations, there's more clarity on how this process should work. But I just think that it was reasonable for the applicant to rely on the conduct of DOB in this case. It's a close case, and I agree with the Office of Planning that if there's another acceptable use, then the board should not grant the use variance. But this case bothers me because, DOB admits they didn't know what they were doing, basically. And so how do we say that this is a self-created hardship? So that's where I am. Those are my thoughts.
Okay, very good. Okay, Chairman Hood, do you want to say something, or do you want me to go?
I'll go last. I'll go after you.
Are you sure? Okay.
I'm positive because I'm going to still be where I am now, but go right ahead.
Okay. This is a very challenging case to me because when I look at uh, the bottom, the top, the timeline, which is the key to me in this whole thing, I see, and I'm going to go through each element of that. What I think. So the whole issue is this is a use variance. Now there are a couple barriers to a use variance. One is if it's a self-created um, situation. And in fact, this is self-created. And on the top, that would be a barrier to a use variance. And I would argue it's self-created, and it is because the applicant purchased the property with the intent to create a 2-unit rental property. The applicant had advice from real estate professionals, development professionals, builders, none of which could decipher. Okay, I take it back. We were also in the process, as they pointed out, and we should get documentation on this about the exact timing and creation of the ADU structure because it's not unreasonable to think that people would not understand ADU if it was just it was just created. So that's an element I would think too. But that said, for these investment professionals not to know the difference between the R2 zone, the zone they're in, and what it is, what can be there, it seems odd to me. And I think that the applicant would have to have had to come up with an idea, had the design work done before they submitted the application, which said, I want a 2-unit flat. So they were asking for something that was not permitted in the zone from the outset. Now, differentiating between a flat, an apartment that's a flat and an apartment that is an accessory dwelling. The reality of it is the difference can be, size, it can be the percentage of the building that it occupies. But the biggest difference, which is the one that's not a waivable attribute, is the fact that it is ownership and the occupation of the owner in one of the 2 units. And even if you had an inspection, it would not tell you who's living in there. It's not, I'd see 2 people sitting there and I wouldn't know if they were owners or not. Or I could ask, your owner? Oh, you're my cousin. It's not clear. So I don't think an inspection would have uncovered the zoning issue. In fact, on one of the exhibits, the applicant put out, said pretty clearly, there, in my mind, I read that and I said, oh, don't worry, there's no zoning inspection with capital letters NO, meaning don't worry, they won't know. And in my mind, but that's my interpretation. That's not factual. The advantage actually, but my interpretation isn't. When I do think that there would have been the fact that you were denied the C of O does give you an indication that something is wrong. And that, if you think about the timeline that which I could decipher, looked like it was in the 2017 timeframe, they would have known then that this may not be something that works. So it wasn't, I don't think it was just till last year or so that we figured out that there may have been a problem. I think there was an indication that there was an inconsistency a long time ago. As far as the reliance, there was reliance on, yes, DCRA, but the applicant has the burden of proof. And they gave us one piece of information, the permit, that talked about that. That's the only thing I have. And we don't have other documentation of the application, although the applicant did indicate that they applied for a flat, but they didn't know what a flat was. They applied for 2 units to rent. And it wasn't clear whether those 2 units to rent would be called a flat or something else. So I think there was a level of confusion there, but I do think also those real estate professionals could have provided some advice on that. All right, so the reliance was on, and I think the Office of Planning indicated the reliance was mostly on them, on the clients. The reliance could have also been in part on both. So everyone had an element of reliance with the applicant had a reliance on several people, and the Department of Buildings did make an error at some point. Now, when they made the error, when they realized it, did they cancel did they terminate the permit? I don't know. We don't have a record of that. That would be valuable to know if there's a trail for that. Then I would have something better to substantiate other than hearsay as to um, what took place at DOB. As far as the hardship is clearly not a typical hardship tied to anything related to the property. There's circumstances, and the hardship is a hardship on a tenant who's actually delinquent and will be evicted anyway. There's a hardship on the owner who has to move into it, or sell it, but that is basically the zone requirements. So I struggle a great deal with this because there are a number of elements in which I think you could argue that this is clearly a self-created situation. It's unfortunate as all get out, but it does seem to me that given the regulations, it doesn't meet the standard. Those are my thoughts, Chairman Hood.
Maybe I should have probably went first. But I would tell you that well, I agree it doesn't meet the standard. We got that. And here's going through this. That's why the timeline would have been fine. Not that it would have changed anything. So I'm gonna try to go off of my memory. But I will tell you this, Mr. Chairman and the board. I believe that if she had not had come back and tried to, I think, solar panels or whatever, none of this never would have come up. If Ms. Harley had not even moved in that direction, this would never come up. 8 years later, she relied on, and she has a permit. And to say that the professionals would have come out and tell you something different or should have found it. Professionals every day tell you don't need permits all the time. They come out here, they do me. But I know better. They tell you don't need permits. I don't do this. They don't do what we do. Ms. Harley doesn't do this all the time. So I think she relied on permit. She proceeded. And I'm not, so much confusion all the way around. And even in our conversation, in our deliberation here, we're having that type of confusion. So for me, a timeline would be better. I don't know how we fix it, but I think she relied on that permit and she proceeded in that permit. I don't know how to get to where I think it needs to be, but I think her reliance was on what she was issued by the government. But I agree. And I don't want to say that some people who are professional help, sometimes they in it for the money. And they don't always give you all the things, but it slid through. But has she not even come back and tried to do what she's doing, I think, with the solar panels, this probably would never even come up. So, and I do remember the conversation about ADUs. I know when we made the change some years back, but I really don't know what to do. But I just think that she relied on the government, and as always stated down here, the government should be predictable, and there was some miscommunications, and that's how she arrived. And the residents, I've always believed the residents should not be punished. That's my statement. That's all I can say.
Okay, so let's see where we are. I guess I would say we probably, well, do we, I don't know if we have a consensus or not. Oh no, do I have to call an emergency meeting? Let's see, do we have a consensus on this? Okay, I'll ask the board simply. Are you prepared to vote, or would you like to get additional information? I would like some additional information if I can get it from the Department of the Building for better justification, if I would support the position. Absent that position, it's challenging. It's not as strong an argument.
Can I say something, Vice Chair? It's not the strongest argument for variance, but here's what, for me, is the definitive issue. Okay. This is in the letter from Mr. Reed. It says, um, where is it? OZA understands that there may have been some confusion as to how an accessory apartment should be represented in the description of work on permit applications at that time. So this was right after the regulations were changed in 2016. We were in the 2017 timeframe, and I joined the board in 2018. There was still a lot of discussion about ADUs, but the Office of Planning also said the same thing, that yes, there was some confusion. That confusion to me is represented in the building permit, which you can't get away from it. It says, it's a flat twice. So that's where I am. With respect to the hardship, it's not an absolute number. It's a financial hardship to the applicant to have, in reliance on the advice she got, converted the basement into a separate dwelling, or to a flat, or yeah. It's a little late. But anyway, that's where I am, and I'm in support. Ordinarily, I would take a more restrictive view in terms of interpreting the regulation, but I think this applicant did everything. Had not there been a statement that the application itself described the scope of work, and that the permit reflected what the application stated, I might not be so inclined to support the application. But I agree with Chairman Hood that the applicant reasonably relied on the permit she had. And had there been an issue, it took DOB 8 years to notify the applicant that there was a problem. I just think that's difficult for me to swallow.
Okay, Vice Chair John, I think I want to say one thing that came to my mind as well as I listened to your comments. I think that the fact that this took place, and I'm not sure when this applicant went to purchase this property, nor am I exactly sure what the regulations were prior. If you were in the process of purchasing a property and the regulations changed in the mid-purchase, you may not know that you can no longer do what you thought you were able to do. So there is an element where the education process may have failed us in making sure that the regulations really did apply in this case. Because if we think about our timeline, I don't think she may have been looking at the apartment in 2016. She may have been, I don't know what that time frame, I'm not familiar with it. But I think we're at a point where we should go ahead and take a vote. So I'm going to ask someone to make a motion.
I'll make the motion to approve the use variance before us to allow a flat with 2 units.
Okay, and we'll need a second.
I'll second the motion. Oh, no, sorry.
Okay, the motion.
I withdraw my second.
No, Commissioner Hood, that's fine.
Oh, okay, I don't usually second, but all right, I'll second.
Okay, that's great. The motion has been made and seconded. Madam Secretary, would you please take a roll call vote?
Please respond to Mr. Smith's motion to approve the application. Vice Chair Blake?
No.
Ms. John?
Yes.
Mr. Smith?
Yes.
Chairman Hood?
Yes.
Staff would record the vote as 3 to 1 to 1 to approve application number 21235 on the motion made by Mr. Smith and seconded by, I believe, Chairman Hood, with Vice Chair Blake opposed to the motion.
Okay, let's call our final case back.
Okay, for the last case, the board is returning to application number 18431A of the Field School. This is a self-certified request pursuant to Subtitle Y, Section 704 for a modification with hearing to modify the order in application number 18431 with modifications of conditions and approval of special exceptions under Subtitle U, Section 203.1M to allow an addition to a building at an existing private school. Under Subtitle X, Section 104 to allow modification of a private school plan, and an application pursuant to Subtitle X, Section 901.2 for a special exception under Subtitle C, Section 1402.1 from the maximum height requirements for retaining walls of Subtitle C, Section 1401.2.
Okay, with the applicant, reintroduce yourself to the record so we can get started.
Yes, good afternoon. I'm Christine Scheiker with the law firm of Holland and Knight, representing the applicant. Our other participants are being brought up at this point. And as they're being brought up, I will let you know that we did submit a clean and a red line version of the conditions as updated to reflect the board's questions during the public hearing this morning. We would be happy to walk through the changes that were made using the red line so you can see the specific changes that were made since we were in front of you this morning. Thank you.
Okay, did you submit the red line to the record?
We did. It is in Exhibit 36A.
Okay,
And the clean
Mr.
copy is
Young.
in 36.
Okay, great. Ms. Young, would you pull that up and let's go through it? Mr. Young? Okay, good. All right.
So Chair Blake, would you like for me to walk through the few changes that were made?
Yes, if we can make it a little bit, maybe I'll make it a little bigger so I can see it. Okay. All right, okay, go ahead.
Mr. Young, if you could go to the next page, there were no changes on the first page except for to identify what it was in the record. So for condition 11, we, as the board requested, reinserted the condition regarding the waste removal, and we limited the times for trash removal to times outside of the drop-off and pickup times. And we specifically included what those times are. This revised condition reflects the current operations that we discussed, but it also provides some flexibility to the extent that the trash route that is currently established moves slightly. In addition, this condition mitigates any potential adverse impacts that could result from conflicts between the trash truck and the pickoff drop-off activities happening at the school, which is consistent with DDOT's request for other private schools. As we discussed, the trash bins are located on the northernmost portion of the site, which is not near any of the existing residential neighbors. In addition, the only neighbor in that area is the Krieger Museum, which is set back more than 50 feet and is shielded behind significant foliage. And based on current operations, the museum is not open during trash pickup. It does not open until 10 a.m. Finally, there have been no issues or concerns raised in any of our meetings with the community or the nearby residents about trash pickup. So we believe that this condition as revised addresses the board's questions and it addresses any potential adverse impact. Condition number 12. This condition has been revised to specifically identify the types of outside groups that could be able to use the field. Specifically, we have identified it to say that the school may allow schools, youth sport organizations, community youth groups, and other educational-based institutions to use the athletic field. So we have further defined that to make it not as wide open as it was in the previous version. We have also incorporated the information that should be provided on the website about it. So you'll see that the school shall include the following on its website: information about the availability of the field, instructions for submitting rental requests, which were the two things that were mentioned before, and we have added and requirements to limit adverse impacts relating to noise in the evening hours. So this is a specific enforceable condition that the requirements should be set forth on the website, and it will help to address the concerns that Board Member Smith raised. Next page, please. For condition number 14, we did not make any changes to this condition due to the open nature of the campus for public use and the specific requirements that are identified on outside groups in other conditions. However, the applicant has no objection to the board reinserting this language in condition 14 that has been maintained out. It is the board's prerogative. We're fine with either one. We just believe that it was more appropriate to have it removed. If we could go to page with condition number 31, please. So it's a couple of pages down. There we go. Well, we're at the top of it. We'll talk through it and go to the next one. So this is the condition that relates to the field lighting. We have deleted the second and third provisions that were discussed in the condition. As you can see, we have maintained that the school shall install the exterior event lighting in accordance with the plans, and that the school shall turn off that lighting no later than 9 p.m. daily. If you could go to the next sheet. You can see that we have deleted the other two phrases that we discussed. The first was the concept relating to limiting potential adverse noise impacts. We have incorporated that into condition number 12 to make it an enforceable condition and not have it be as general as it's set forth here. And then secondly, we removed the condition regarding working with the community for potential issues because that commitment continues to be stated in condition 31, in condition 38. Condition number 32, we reinserted the time frame for turning off the lights in the parking lot. We have identified that it is 11 p.m. as we discussed in the hearing this morning. Again, I will note in all of our discussions with the neighbors in the ANC, there were no issues or concerns raised about the parking lot lights, which have been in existence for the last 13 years. So there were no issues that we're trying to mitigate, but we have put a time frame on here as the board has requested. And then for the construction management, in response to the questions about enforceability of construction management, we have confirmed that all of the concepts in this section were included in the record in a little bit different language, but generally the same. So we are proposing that you just reference that there's a construction management plan and you can delete the conditions consistent with Board Member John's discussion. If we could go to the next page, please. Condition 38, which we find is a very important condition, we have only deleted the last phrase to reference a specific example of what could be talked about. However, the applicant confirms that any issues can be brought up during these meetings that are going to happen at least every 6 months. So the applicant does commit to the community that any issues can come up, and so we don't need to have any examples of those. And so therefore, with these changes, we believe that we have addressed the concerns of the board. We believe that we've met the burden of proof as well. And our team has worked very closely with the community and enjoys strong support from the community, I believe, due to its willingness to work in real time with the community when issues come up. That is why we arrived at this hearing with so much support. We believe that these conditions as proposed to be modified do mitigate any potential adverse impacts, and they reinforce the applicant's commitment to continue to be a good partner in the community. And with that, I'd be happy to answer any other questions you have. Thank you.
Okay, I'll turn to the board. Does anyone on the board have any questions for the applicant with regard to the application or in regard to the provisions in the conditions statement?
I don't have any objection. I just wanted on condition number 32, where we have replaced the language to state that the school shall turn off the lights to the parking lots. I would suggest no later than 11 p.m. instead of at 11 p.m.
Thank you, Board Member John. That's a good change. Sorry that we did not catch that. That's better language.
Mr. Chairman, I do have a question. Ms. Shiker, on the waste drop off and pickup, do the kids ever get out of school early?
Ms. Strauss, could you answer that?
I would say they get out of school maybe 2 times a year early, not very often, if ever, on a conference day.
I just think that okay, I'm not going to. That's too much. Okay, that's very de minimis. Okay, thank you. I just wanted to make sure we covered here. I don't know if the times still. I kind of go back to what you all had proposed previously, but I know my colleagues wanted the timing in there. So if I get out if we get out one day, I'm in field school and I get out at 12 o'clock, and the trash is happening to come by and pick up at 12 o'clock. So I kind of go back with what you all have proposed, but if my colleagues are fine with the timing, I'm good with it. Thank you. Thank you.
Okay. I think we are pretty much moved on with this. Ms. Shiker, do you have any closing remarks?
I would just reiterate that we do believe that we have met the burden of proof for both the modification to the private school plan as well as for the retaining walls. The school is excited and prepared to move forward with these projects as soon as it receives approval of the application. As such, we would ask if the board could consider it as soon as possible, and we appreciate your consideration. Thank you.
Thank you. So I'm going to close the hearing in the record. And dismiss the witnesses. And we can begin our deliberations. Would anybody like to lead this?
Okay, so I'll start. So I thought the application was quite clear, and I appreciate that the field school and the community worked together to come up with solutions that would be that would work for both the school and the community without, you know, unduly compromising the school's educational purpose. In terms of how the application meets the requirement for relief, the increase in enrollment is from 320 to 400 students, and increasing faculty staff from 74 staff members to 110, which is not significant in the scheme of things. The addition, I think, meets all of the development standards. And so I have no objection to that as well. And I thought that the site plan was really quite, I don't want to say impressive, but I do like how the new building was sort of, it continued what was there before, and is well integrated into what was there previously. I thought that the applicant explained why the 3 retaining walls needed to exceed the limits as required by the regulations, and I believe that it met the criteria for relief. And in terms of the conditions, I appreciate the applicant's willingness to review again with the community the changes that the board suggested. And I think all of these conditions will help to mitigate any potential impacts on the potential adverse impacts on the community. And I think this is remarkable that there is a private school application for relief that can be heard and decided in one day. I think this is a first. Thank you. And I'm in support of the application. Thank you. Oh,
Okay.
I'm gonna give
Mr.
great
Smith?
weight. I forgot to say, I'm gonna give great weight to the Office of Planning's analysis and recommendations. And I appreciate the ANC's report. And that they granted subject to the 38 conditions, and because the board addressed those conditions, I believe that that whatever concerns the NC had have now been addressed. And let's see, I also appreciate DDOT. I believe there was a report from DDOT. I would just note that the order should reference the construction management plan as we discussed in the hearing. And that's it, Mr. Vice Chair. Thank you.
Thank you very much, Ms. John. I appreciate that very thorough analysis. Mr. Smith?
It's very thorough. I don't think I have anything to add. I agree with her assessment and the Office of Planning's assessment of this particular case. And looking at the site plan, this is a very, as Ms. John stated, this is a very thought out design that I think would be the least impactful. They're tucking the new addition into the rear of the existing building, so there wouldn't be any visual impact, I think, from the street. And the existing vegetation, I think, would screen it from any of the residential buildings to the east and the south. The particular project complies with all of the other, I think, regular, the standard development standards that have become issues in previous school cases of this particular matter, which relate to parking and pick up and drop off. That's not a concern in this particular case. So kudos to the applicant for making sure that they were designing a project that would have the least adverse impact on the surrounding neighborhood, given all of the issues that were raised prior to me sitting on this board when it came down to previous special exceptions for this particular school. So with that, I give OP staff report great weight, incorporating the conditions as we just discussed, and I will support.
Chairman Hood?
Thank you, Mr. Chairman. I would agree with what I heard, but I want to especially thank this applicant for all the diligence they did in working with the community. And I would agree with Ms. John's analysis to the T, as well as Board Member Smith. Thank you.
Thank you. I too agree with the analysis prepared by Board Member John and Board Member Smith and the chairman. I appreciate it. I think that the applicant has done a great job, has met the burden of proof for the retaining wall, as well as the modifications for the many modifications in the plan. I will be voting in favor of application. And with that, having deliberated, I'd like to make a motion to approve the application as read and captured by the secretary with the conditions as presented in Exhibit 36A, and ask for a second. Ms. John.
Second.
Motion has been made and seconded. Madam Secretary, would you please take a roll call vote?
Please respond to the Vice Chair's motion to approve the application with the conditions listed in Exhibit 36A. Vice Chair Blake?
Yes.
Ms. John?
Yes.
Mr. Smith?
Yes.
Chairman Hood?
Yes.
Staff would record the vote as 4-0 to 1 to approve application 18431A with conditions on the motion made by Vice Chair Blake and seconded by Ms. John.
Thank you. Madam Secretary, do we have any other business for today?
We do not. Great job,
Then
Vice Chair.
Then this meeting is adjourned. Thank you, everybody. Bye.
Thank you. Bye.
Let's do this again.
Yes.
Good job.
All right.
Bye.